Oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 21-5091, Gentiva Health Services, Inc., appellant versus Xavier Becerra in his official capacity as Secretary of U.S. Department of Health and Human Services. Mr. Rissler for the appellant, Ms. Neumeister for the appellate.
Counsel for appellant, you may proceed.
Good morning. May it please the court, Jared Rissler for appellant. I'd like to reserve 1 minute for rebuttal. This case concerns the application of two cost-cutting measures, the Budget Control Act and the aggregate hospice cap. Applying each according to its plain language is straightforward. The Budget Control Act requires a 2% reduction to, quote, individual payments for services. The hospice cap statute applies to the aggregate, quote, amount of payment made by Medicare for a 1-year period. The two provisions here can both be applied according to their plain language. There's no conflict in reducing individual payments for services by 2%, as required by the Budget Control Act, and then applying the aggregate cap to the hospice's aggregate amount of payment made, as required by the hospice cap statute and the agency's published interpretations of it. In fact, that's exactly what the Medicare contractors initially did in this case. The agency wasn't satisfied with that outcome, and in March 2015, it secretly instructed the contractors to change the way that they applied the hospice cap. The effect of these instructions was to apply sequestration to the hospice's aggregate payments, rather than to their individual payments for services made as Congress had instructed. Now, the Secretary observes that if we tweak the language of the Budget Control Act, if we apply the 2% reduction to hospice's aggregate payments, rather than their individual payments for services as Congress instructed, then this will result in the maximum possible savings or maximum possible recoupments from hospices, and thus the greatest savings for Medicare. But the Secretary has not identified any language in the Budget Control Act that applies the 2% reduction to anything other than individual payments for services. And you will search in vain to find any such language in the statute.
Can I ask you something about that? It says individual payments for services furnished during the 1-year period. Now, these payments that you got, were any of those for services across a 1-year period, or were they for smaller periods of time?
All of the payments, that's a good question. All of the payments were per diem payments that were issued for claims submitted for specific services.
Were they for services that were furnished during a 1-year period or for a shorter period?
Well, the individual payments, no, they're per diem payments, and so what happens with
and aren't they made monthly? Are they made monthly?
They are made monthly. That is correct. Pursuant to claims that are submitted for services at a daily rate. As well, the 1-year period that's referenced in the Budget Control Act is the 1-year period starting with the order for sequestration, which in this case would be April 1 to March 31. The aggregate hospice cap applies to an entirely different time period from November 1 to October 31st.
Can I ask you about, go ahead.
The amount made of payment for the services ultimately is the reconciled amount of payment, not the payments that are made as, through the year as the services are being rendered. There's no question that the legally required payment is the reconciled payment at the end of the year. Isn't that right?
Well, the only payment that is made to a hospice are these per diem payments. Those payments are the amount of payment made under the language of the statute are subject to an aggregate cap. But there are providers that receive interim payments And where that happens, that there are regulations governing the interim payments. And those interim payments occur when providers are paid on a cost reporting basis. So
But
that
in the ordinary case, when there are payments being made, per diem payments being made monthly, so that the providers have a cash flow, there's no determination of what amount the providers are actually entitled to until the cap is determined after the fact and applied. And so when you're talking about payments made as a sort of literal matter, payments are made, they're disbursed, but they're not payments that are to which the providers are legally entitled for the services that they provided until the reconciliation has happened under the cap. Isn't that correct?
Well, the amount of payment made under the hospice cap statute may not exceed an aggregate cap. And so the amount of payment made, and this is, it's in the statute, but I think it becomes even more clear with the Secretary's interpretation or implementation of that statute in 42 CFR 418.3 AD, and then even more so in CMS's manual that makes clear that the aggregate cap is applied by comparing the amount of payment made, the manual calls it total actual Medicare payments, to an aggregate cap.
Can I ask you about your reading of 906D3B? Because that, since the Budget Control Act can apply, quote, on a basis relating to the reasonable cost incurred for the services during a cost reporting period of the provider. When you look at the payments received by hospice during a cost reporting period, doesn't that already include the aggregate cap?
No, the hospices are not paid according to a cost report. The per diem payments are final payments. They're not reconciled based on costs incurred. And so there is no.
Well, no, there's the application at the end of the year. There's the application of the aggregate cap, and there may be other adjustments, if I understand this scheme. So there is a form of reconciliation that happens at the end. It may be tailored to your situation, but your payment for the cost reporting period is determined at the end of the year through the reporting process. And that process includes application of the aggregate cap, right?
Yes, there is.
The per diem payments are not final payments, because if they go over the aggregate cap, you'll have to return some.
Well, the per diem payments are subject to an aggregate cap, which is
right.
over a period of November 1 to October 31st.
Right, over a year.
Right.
All I'm trying to do is clarify what's meant by payments over a cost reporting period. And that would include in the hospice. I'll tell you my understanding, if you can tell me where I'm wrong, because you understand this better than I do. It's pretty complicated. But my understanding is that cost reporting period, the year time, the 12 months you mentioned, you have the per diem payments, but then at the end of that, there's a final reckoning as to the payments, and that there can be adjustments. And part of that process includes application of the aggregate cap and any adjustments that need to be made because of that. Is my understanding correct?
Well, with one caveat, I think the
Okay.
language for the cost reporting period is coming from the Budget Control Act. I'm not sure that language is in, it is not in the hospice cap aggregate cap statute. That period is referred to as the cap period, as opposed to a cost reporting period, because hospices are not paid on cost. And that aggregate cap is calculated against net reimbursements. Other adjustments are made, as the Secretary acknowledges, in its briefing at pages 44 and 45, the aggregate cap is applied after other adjustments.
Okay.
And the Secretary offers no reason why sequestration should be treated differently than other adjustments.
So does that cost reporting language apply to a different part of the Medicare Act? Is that what you're saying? That doesn't apply to the hospice provision?
I think that's right. Hospices are not paid on a cost reporting basis. They do have an aggregate cap that applies.
Right.
It's not, strictly speaking, a reconciliation because they are not paid on a cost reporting basis, but they do receive a notice of final reimbursement that applies the aggregate cap.
Okay, so you're saying, I just want to make sure I understand. I think, can you tell me, I don't want to put words in your mouth, so tell me if I've got it wrong. Your reading of the language I quoted from 906 D3B is when they're referring to cost reporting periods. That's different aspects of the Medicare Act, maybe hospitals, because they go through a cost reporting process and hospices do not.
That's right.
Okay, thanks.
Sorry, go ahead.
No, you go ahead.
No.
I was just going to ask how you square the way you would propose reading the statutes to time the calculation of the sequestration with the explanation, the example that the district court provided at JA 249 at page 10 of the slip opinion, that shows that your method wouldn't apply the sequestration to hospice B, which was the less efficient hospice, and would apply it to hospice A. That seems contrary to the budget control mandate to reduce the Medicare spending by 2% across the board. And it just seems perverse to reward the less efficient provider in that way.
First, the hospice cap is not a matter of efficiency. Hospices cannot avoid the cap by being more efficient. The hospice cap is a comparison of two numbers: an aggregate cap, which is determined by essentially the number of Medicare beneficiaries that a hospice serves, and the amount of payment made, which in a per diem system is the amount of the number of days of services being provided. And so a hospice that exceeds its cap did not necessarily provide services inefficiently. It merely provided more services than compared to the number of patients on its census. Essentially, it comes down to a length of service, and the argument of efficiency is essentially one that patients remained on hospice too long or lived for too long. It has nothing to do with the hospices spending too much providing care.
I'm not sure I follow. It sounds like you're arguing with the policy behind the cap. I mean, are those examples incorrect in the district court's opinion? I thought they were illuminating, and to the extent that the cap would apply to the one that spent more and not to the one that spent less, it seems like you're saying, well, that's a erroneous or misled policy choice.
No, that's not it at all. The hospice cap applies, and we're not questioning the application of the hospice cap. So take, for example, a hospice with an aggregate cap of $98,000. With sequestration in effect, that hospice would need to deliver $100,000 of services in order to exceed the cap. And so this notion that hospices that exceed the cap have avoided sequestration is not correct. Those hospices have had, as the Budget Control Act requires, their individual payments for services reduced by 2%. So there may be services above the 100,000 in that situation. The hospice has continued to provide services. It paid its nurses, paid its chaplains, its social workers, its administrative staff. It continues to pay for patients' medications. And it continues to submit claims, and those claims are paid at 98%. The effect of the cap is that those payments made above the cap have to be returned. And so the notion that hospices avoid the cap, or excuse me, avoid sequestration because they're subject to a second further cut under the hospice cap statute simply is not the case. There are other adjustments that are made to hospices payments that the Secretary in briefing admits those adjustments must be made before application of the aggregate cap. And so take a hospice that had $100,000 of payments, but that are reduced by $5,000 for Medicare secondary payer and $10,000 for the inpatient cap. That hospice then has net payment of $85,000. If the hospice's aggregate cap is $70,000, that hospice is paid $70,000, regardless of, which would be the same even if the Medicare secondary payer and the inpatient cap had not applied. And the Secretary acknowledges that that is the right result, even though one could make the same argument that by applying the aggregate cap after those adjustments, the hospice has essentially avoided those pre-cap cuts.
Wouldn't, let's make sure I'm understanding this right. Wouldn't that money that was taken off in advance, that 2% off the per diems, wouldn't that have come off in the end anyhow? Because that 2% would have been part of what would have been over the aggregate cap anyhow. So it wasn't really sequestration. It was almost, I know it was called sequestration, but financially, it's no different than if they had simply sort of somehow been able to see into a crystal ball and cut back based on the aggregate cap early. I mean, you would have lost that same money due to the aggregate cap. I think that's what I thought the district court was saying. And so that's my question. You wouldn't have gotten it anyhow.
So I think in the example of being able to see into the crystal ball, let's take the example of the hospice that has a $98,000 cap. And let's pretend that we could see into the crystal ball and Medicare could simply cut off payments at the point that the quote amount of payment made exceeds $98,000. In a sequestration year, that provider would provide $100,000 of services that would then be paid at $98,000. At the point after the hospital, at the point after that is where you would cut off payments. Under the Secretary's position, the payments cut off not at actual amount of payment made of $98,000, but at 2% less than that.
I don't see that. I mean, on your example, which I see at JA 249, which is page 10 of the district court's opinion, the 2% sequestration in table 2 per Gentiva's argument leaves the final amount retained by hospice B at 1,000, not 980. And I thought you just said that, you know, it should, assuming that it should come out the same way if we had a crystal ball, and that under the crystal ball scenario, hospice B would retain 980. Is that not what you were saying?
So in column A of the district court's example, the actual payments, which is the $980, the 1,000 reduced by 2%, is less than the aggregate cap of $1,000.
Right. This doesn't kick in for that.
Right. That's right. Because and under our view, that's the correct result for the $1,000.
But what about under column B? Why?
So under column B,
I thought you were saying that if they were paying and knew as they went along that the cap was going to be 980, that they wouldn't pay beyond that. And so the result should be, even if they did mistakenly pay beyond that, the result should come out that the final amount retained by the hospice is in column B, 980 as well. But you're saying no.
No, the final amount in column B should be $1,000 because the actual payments made after sequestration are the $1,176.
But I thought if we
of-
equate what should happen with what would happen if we had the crystal ball and knew what the cap was going to be, then CMS wouldn't have paid 1,176, but would only have paid 980.
If we had the crystal ball and the aggregate cap was $1,000, Medicare would have stopped paying at $1,000.
And because of sequestration, it was down to 980.
Right. If Medicare had the crystal ball in example B and the aggregate cap was $1,000, and the amount that would have been paid in the absence of sequestration is this $1,200. So those payments, those individual payments for services that together add up to the aggregate amount of $1,200 would have been reduced by 2% at each claim. And at the point that those sequestration reduced payments, the amount of payment made equaled $1,000, it's at that point that that Medicare would have stopped paying. So the $1,000
what I was trying to say is the amount that was sequestered in those individual payments, the sort of the per diem payments, the 824, if I have my math right, between 1,200 and 1176 in column B. You weren't going to get to keep that money anyhow, just because of the aggregate cap, right? They took it out and called it advanced sequestration, but you were never going to get that money anyhow because of the aggregate cap. So counting that as your sequestration payment is sort of double counting for you. You're not actually paying any sequestration. You're just not getting money that you were never going to get anyhow. And so that's why they had to take another 2% off at the end to make sure that for Hospital B and Hospital A share the pain equally, and both actually end up getting 2% less than what they would have gotten at the end of the year when everything is sorted out, which would have been 1,000 max.
Well, Hospice B receives payments that are reduced by sequestration during the year. And according to the Budget Control Act, these are the individual payments for services. They are reduced. In order to get to the $1,000 cap in a sequestration year, that hospice needs to provide services that are worth more than $1,000. They provide $1,000 plus the 2%. And those individual payments for services that otherwise would have been made at say $1,020 are made at $1,000, and any payments above that are subject to the hospice cap. But these
why is the hospice cap raised for a hospice that spends more? It seems like the cross-check for whether sequestration has occurred has to be that no hospice is able to pay more than another hospice and as much as they would have had without sequestration. And it sounds like they may be getting less per service, but they're allowed to provide and get reimbursed for more services by effectively having a higher cap. And I guess you were saying before why you think that's consistent with the notion of the dual application of the cap and sequestration, but it's not at all intuitive to me why a hospice that does more services for more patients thereby gets effectively a higher cap.
Well, providing more services does not create a higher cap. The cap is created by by statute is calculated by a per beneficiary amount times the number of Medicare beneficiaries. So that cap amount is not adjusted upwards for hospices that provide additional services or have additional costs. That is purely a fixed number that applies to every single hospice across the board. So it's an amount that's set every year. In this case, it was, I believe, $26,157.50. And that number is multiplied by the number of Medicare beneficiaries that the hospice serves. And that's the same across the board for every hospice. Hospices that are below the cap retain all of their payments. They don't get any additional payments because they stay below the cap. They retain all of their payments, sequestration reduced payments. And the hospice that is above the cap has its sequestration reduced payments further reduced. They've already received a 2% sequestration during the year. That's taken out of their payments before the contractor sends the money to the hospice. So they've already had that 2% taken out.
But my point was that that 2% they thought was going to be a sequestration payment, in fact, didn't, because it was just enforcing the aggregate cap. In reality, it was money. What I don't understand is if that's money you were never going to get anyhow because of the aggregate cap, right? That you weren't going to get the 200 under the 1200 theory, and you weren't going to get the extra 824 because that they took out because of the 2% sequestration. That was never going to be your money anyhow because of the aggregate cap, right? Are we agreed on that? That 824 difference between 1200 and 1176 was never going to be money that the hospices got to keep, even if there were no sequestration. Is that right?
That is the essentially the same argument as.
I'm just asking a fact question. Is it right? I'm sorry. I have to go very slow here on this stuff. So just a fact, am I right in understanding that 824 that was taken out here, that in a normal year, I guess you would have gotten your 1200 in per diem payments under column B, hospice B in this column. And instead you only got 1176. So that's an $824 difference. These are tiny amounts and they aren't the right amounts, but you were never going to get that money anyhow. Even without sequestration, you wouldn't have got that money.
Yeah, without sequestration, the aggregate cap would have pushed would have required the provider to return everything in excess of $1,000. Right.
So that 824 that they took out just because they were trying to get ahead on the sequestration thing for the hospitals that overpaid. In fact, it ended up not really being a sequestration payment at all because it wasn't anything sequestered as to that hospice's payments because they were never going to get that money. So at the end of the year, they had to go, wow, hospice B, you haven't contributed anything to the sequestration process. You still want to get your full 1,000. We have to pay the sequestration. Everybody has to feel the sequestration pinch the same. And that's all they did here with you. So it's not really, I understand they called them sequestration payments during the year, but in fact, the reason they went through the calculations they did is that for hospices that were over the cap, those so-called sequestration cuts during the year were in fact not enforcing sequestration. It turns out all they did was enforce the cap a little bit earlier than normal.
Well, sequestration, according to the Budget Control Act, applies to individual payments for services. And Medicare, in implementing the sequestration cuts, instructed the Medicare contractors to apply sequestration to individual claims for services. And that's precisely what was done.
My factual understanding is accurate as to this table in the math that the 824 that you lost to so-called sequestration was in fact not money the hospice lost at all. It was never going to get to have that money or keep it in the first place because it was over the cap. And so then then it seems like you're just going to your textual argument, which I understand, about individual payments in 906D. But then those payments weren't for services furnished during the 1 year period, right? Because they weren't final as to that until we got to the end of the year and everything got its final reckoning.
The payments, I mean, the only payments that a hospice receives are the individual payments for services, the per diem.
But you don't receive them, and that you don't keep them if they're over the cap. So there has to be a reckoning at the end of the year. And they figure out how much of those checks we sent you during the year, in fact, were for services furnished during that year, consistent with law, right? Under the statutory scheme.
Under the hospice cap statute?
The 906D1A is talking about all of A and B of the Medicare Act. And so it's looking much more globally. There's no specific provision here for the hospice statute. It's all of A and B. And that is statutory schemes that require an end of the year reckoning. Your reckoning is a bit different than, say, hospitals do for the reasons you've explained very well. But at the end of the day, they're talking about payments over a 1 year period. But that's one reading of the statute. And that's when that payment you received, say you got, I can't do the math, but you got $200 for a 1 month payment. I know these are very small numbers compared to reality, but my brain can't do the bigger numbers. $200 for a month, but it turned out that you're only entitled under the statutory scheme to 150. That 50 of that was actually going to be over the cap anyhow. And so that wouldn't it be difficult to say that $200 payment rather than 150 you really should have gotten because of the cap is what Congress was referring to when it talked about individual payments for services furnished during the 1 year period.
But I don't think that the amount of payments remaining after application of the aggregate cap can be characterized as individual payments for services, which was the specific language that Congress chose as the means for implementing the Budget Control Act. It had broader language that goes towards the goals, but as this court has previously explained, it's for Congress to choose the means for implementing its goals, and the means and language that Congress used was individual payments for services. So the aggregate cap.
Yeah. Excuse me. Go ahead.
The aggregate cap applies to an entirely different amount, which is an aggregate, the amount of payment made by Medicare for an aggregate 1 year period. And so the issue with the hospice having, any hospice that is above the cap after adjustments, whether those adjustments are sequestration, Medicare secondary payer, or inpatient cap, any hospice that after those reductions remains above the cap is going to get paid, or is going to retain payments at the cap.
All right, counsel, I think we have your argument, and this is somewhat repetitious in your responses to Judge Millett.
I think I was repetitious in my questioning.
Well, maybe so, but I mean, we're not covering new ground here. I think we get your argument. Why don't we hear from counsel for appellee, and then we'll give you your minute for rebuttal.
Thank you.
So, counsel for appellee.
Thank you, Your Honor. And may it please the court, McKay Newmeister for the government. I'd like to start by taking a step back and focusing on what this case is about. The plain text of the Budget Control Act required a 2% reduction to Medicare spending, which can only be achieved for hospice payments if applied after the aggregate cap, which is precisely what the agency did here. Gentiva's view of the statute, by contrast, would exempt them from the effects of sequestration entirely.
Well, I'm sorry, they argue that it wouldn't, that you're basically getting a bargain on each and every service provided, because as the payments are made throughout the year, they're made at a 2% discount for all of them. So in the aggregate, the government will get more services for the capped amount than it would without sequestration. And that itself, I gather, appellant is saying, is a saving to the government.
It's not though, Your Honor, because if you look at the amount that Gentiva would be entitled to receive for the aggregate services that it provided over the course of the entire year, with or without sequestration, under its approach, that amount is the same. And so the total outlays from the Medicare program for that year have not been reduced at all to these hospices that are exceeding their caps.
Right, and
so
my understanding is their position is, yeah, but they have to work harder and provide more value to get there.
Well, Your Honor,
so you're getting more product at a discount. I think that's his position.
Yeah, Your Honor, the way that this works is that the hospices have to provide the services that are required under the statute, regardless of what is going to happen at the end of the day. These individuals, if they're eligible for hospice benefits, are entitled to keep receiving those benefits, even if the hospice provider is not properly controlling its costs and those costs go over the cap. And so it's not that the government is receiving more bang for its buck. The government will receive the same amount of services, or rather these beneficiaries would receive the same amount of services either way. But the aggregate cap is a cost control measure, and Congress implemented it to ensure that the costs that were being paid for hospice care didn't exceed what the government would otherwise be paying for a conventional care setting for those same patients. And so these hospices are supposed to control their costs, keep their aggregate costs under this cap for the year. And under Gentiva's approach, we have an incongruous result whereby hospices that are properly controlling their costs and keeping them below the cap are subject to the full effect of sequestration and bear the brunt of these cuts, whereas the hospices that are not controlling their costs and are going over the cap don't end up seeing any reduction at all for the year. And that's what the district court referred to as the difference between an efficient hospice and an inefficient hospice. And it's perverse, it creates a perverse incentive, Your Honor, for these hospices that are not controlling their costs. It actually creates upward pressure that would incentivize them to shade over their aggregate cap to make sure that they can actually keep more in reimbursement for the year in order to avoid the full effects of sequestration. If that's indeed the statute that was enacted, it would be very surprising, because rather than reducing Medicare spending for hospice care by 2% across the board, for a significant percentage of hospices, there would be no overall reduction at all. And hospices would face this upward pressure that I discussed to actually increase costs instead of decreasing them, which is what both of these measures intend to happen. Thankfully, that's not the statute that Congress enacted, though, as the district court correctly held.
Can I ask you about 906D 3B? The talks about cost reporting period. And Mr. Reisler said that doesn't apply to hospices because they don't do cost reporting, certainly in the way that many other Medicare participants do. Do you agree that 3B doesn't apply to them on that basis, or do you believe that hospices do file cost reports?
So, Your Honor, I'm not exactly certain whether the agency treats 3B in particular as applying to hospices, but I will explain what happens with hospices with respect to what you would consider to be a cost report. So cost reports are a term that's used generally to apply to hospitals, and they have a cost reporting period and they file cost reports at the end of the year. If you look at 42 CFR 405.1803, it's the regulation titled Contractor Determination and Notice of Amount of Program Reimbursement. It talks about the end of the year.
What page are we on the?
I'm so sorry. So it's the regulation is 405.1803. Let me just find that in the addendum really quickly. I believe it's in the addendum. Yes, it's A16 of the addendum to our brief. So this regulation applies to the end of the year process by which various providers are issued a determination of their overall reimbursement, the overall notice of program reimbursement that they are entitled to receive for the year. And this applies both to hospices and to hospitals that have a cost reporting period. And as the notice explains, there's cost reports that are filed by other entities, but at A3, it mentions the hospice caps, and it says that with respect to a hospice, the reporting period is the cap year. And so it's essentially indicating that what you would call cost reporting periods for other entities, that's the cap year for hospices, and a cost report for other entities is essentially this process of filing their self-determination of cap amount that the hospices have to follow. I believe that's under 418 308C. I want to point you to one other source, Your Honor, and that's the provision for PRRB review. That's 1395.00. Let me find that in the addendum as well. Let's see. So A4 is 1395.00, I believe. And we don't, so the most relevant provision is not included in this, Your Honor, but sure that I have the right page. And if you actually look at the first provision of that, it's establishment, and it talks about the review of the PRRB, and it says that any provider of services which has filed a required cost report may obtain a hearing with respect to such cost report. But that also applies to hospices. They don't technically file what's defined as a cost report. They file these cap notices. They self-determine their caps. And that's ultimately what they get to challenge through the PRRB, which just demonstrates that it's a different term, but it has certain similarities. And as Your Honor, as the questioning, my friend on the other side revealed, there are reasons why these cost reports, there are reasons why the total amount of program reimbursement to a hospice at the end of the year differs from the amount of payments that are paid out as periodic reimbursements throughout.
Can I ask you one other thing about this Budget Control Act in D1A? The language that they're relying on, the individual payments for services, which has a sort of understanding within the hospice system because of the way it works with per diem payments. But Congress there was speaking about A and B of the Medicare Act, parts A and B of the Medicare Act, which is a lot of ground to cover. So when you talk for a hospital, is the term payments for services or individual payments for services used, or how is individual payments for services, what was it meant to cover? And how do we know that, given that it was an umbrella term for everything that happens under A and B?
So in the context of hospices, Your Honor, you read the language of this provision, individual payments for services, but it needs to be read with a view to its context and its place in the overall statutory scheme. So you read it in light of the rest of the structure of the Budget Control Act, and you also read it in light of the nature of the program statute. So for hospices, that's 1395 FI1 and FI2. And you can see that in context, payments to hospice providers are treated in the aggregate for an entire year based on all of the collective services that an individual provider has provided for that year. So in this context, individual payments for services means the payments to the individual providers.
Yeah, I think I was trying to ask a different question. And that is, if they say for a hospital, right? So we're under a different part A here. We're talking about hospital payments, or B. Where in the process for hospitals, which get paid based on, I think if I recall, past cost estimates, and then everything gets adjusted at the end, what in that process counts as an individual payment for service?
So
where did Congress get this phrase, individual payments for services? It must have talked to somebody at HHS.
I'm not exactly certain, Your Honor. I know that these are generally referred to as fee-for-service claims, so it's possible that they're in Part A and Part B, so they're thinking about in terms of services. The concept of individual payment amounts has been part of the special Medicare rules since it was first enacted in 1985. This provision was first enacted in 1985. And I know that the PRRB, in talking about this, explained that for a certain segment of hospitals, the agency applies sequestration essentially the same way that it does for hospices. And that's a footnote in the
preliminary
PRRB.
payments and then again at the end.
I believe that's correct, Your Honor. On JA13 and it's note 64, it's talking about hospitals exempt from the inpatient prospective payment system, and explains that these hospitals are subject to sequestration in a manner similar. I'm not exactly sure what the details of that are, Your Honor, but sort of stepping back, regardless, the way that this provision should be read.
Wait, so just, I know how you guys want to interpret it, but I'm just asking, there's no language in other parts of Medicare A or B that uses the phrase like payment for service or individual payments for services. That's not a statutory term that appears somewhere.
I'm not aware of a statutory provision that uses the phrase individual payments for services that Congress might have been meaning to invoke here. If you look at the Medicare statute specifically for hospice payments, the relevant provision is titled Payment for Hospice Care, and talks about how payment for hospice care works and how services should be viewed, and how payments go to on the basis of individual providers. But regardless of the specific Medicare program that you're talking about, the way to interpret individual payments for services is to look at the way that program functions and then the way that Congress structured the rest of the Budget Control Act to determine.
Okay, I just want to know if for hospitals and whoever else is covered under Medicare A and B, is sequestration applied at the end of the year and after all the reconciliation has been done to ensure that each hospital, each participant, whatever form they take, is paying its share of the sequestration?
So that's certainly what the footnote that I pointed to in the PRRB decision suggests for hospitals that are exempt from the inpatient prospective payment system. I'm not certain.
That's a small number.
Correct, Your Honor. I'm not certain what other off the top of my head what other systems are in place that CMS has used to implement this. We do have the upfront 2% reduction for fee-for-service claims under Part A and Part B, and then obviously the technical direction letter was issued here specifically about how to do this for hospices. I believe there is other similar directives for other programs. For instance, the IPPS exempt that I just referenced, but I'm not certain, Your Honor.
Okay.
Can you speak briefly to the notice objection?
Yes, Your Honor. So ultimately, the agency was implementing sequestration under the mandatory directive of the Budget Control Act. It had to implement sequestration such as to achieve this 2% reduction after the aggregate cap. And because it was subject to this mandatory requirement, any potential procedural mechanisms that, might otherwise apply aren't to the contrary. But in any event, the hospices were informed about how this would work by their contractors. The technical direction letter instructed contractors to issue a listserv telling hospices how this would be applied. There was also a forum that was held in November of 2014 at which they were made aware of this, and that's sort of referenced offhand at JA 213 note 1 is where that's referenced in this record. And because ultimately because the Budget Control Act has this mandatory statutory directive that required this result, that was putting providers on notice about how this would ultimately work. And at the end,
are there other examples of situations like that where the directive comes straight from Congress, and so it just really there isn't really room for the agency to implement through notice and comment rulemaking? It just has to apply. Are there other examples that you can point us to where there isn't that sort of more hand-holding kind of individualized notice to these actors?
So I don't have a specific example of that, Your Honor, but I will note that the district court found that plaintiffs had not identified any reliance interests that were not being respected here. We raised that in our brief as well in the context of whether there had been any prejudice and the rule of prejudicial error. And in reply, plaintiffs still have not identified any prejudice that they might have suffered based on just the timing of awareness of this policy. And indeed, it's supposed to be a reduction in sequestration is a reduction in overall spending. It's a reduction in these programs. And so something being applied at the back end when the caps can be properly calculated. It's not surprising that there would not be prejudice from this.
Does the government have a view on whether enforcement of its view of how the Budget Control Act was supposed to work here? So just for this question, assume that you're right on the merits. Whether that enforcement, that cutting that 2% that Congress said everybody has to do, or at different levels, but everyone has to cut, counts as a sanction for which ascertainable certainty is even the right standard?
So we explained in our brief, Your Honor, why this isn't quite the right fit based on the precedents that plaintiffs cited about fair notice, because this really is not, in general, not the kind of requirement that's being directly imposed on them that they're being penalized for violating. So just on sort of a general conceptual level, this isn't quite a match. I don't have a specific answer about your sanction question, but I think
it's not that they violate. The aggregate cap takes care of any, I don't know if we even call it a violation, but we'll just say sort of spending more than we're going to pay for. But enforcement sequestration is not a response to an individual provider's behavior or failure to conform to statutory regulatory requirements in the way that a sanction would be, right? This is just a share the pain all around.
It is meant to be sort of an across the board cut that's applied evenly across programs, with Medicare getting a special limited reduction. And another way to think about it that I think is sort of similar is that, the question about fair notice is about whether CMS is imposing requirements and interpreting its processes to impose certain requirements. But here we have this independent statutory mandate from the Budget Control Act that independently applies and requires this result. And so, again, there's just the mismatch between saying that an agency didn't give for a notice of something that was independently required by Congress through statute.
Thank you.
Anything further?
No, Your Honor. If there are no further questions, we would ask this court to affirm.
All right, thank you.
Yeah.
So, counsel for appellant?
Thank you, Your Honor. Just quickly on 2 points. The government said that there's an incentive to be inefficient and to exceed the cap. Hospices that exceed the cap have to return the amount of payment made in excess of the cap. There's no benefit at all to exceeding the cap. Hospices decidedly have an incentive not to exceed the cap, because every penny that they receive above the cap has to be returned. And that's true regardless of sequestration or no sequestration. So there simply is no incentive to be inefficient or to exceed the cap.
All right.
And briefly on the briefly on the notice issue, we agree that there was no need to provide notice of the 2% reduction to individual payments for services. That was required by statute. But what the agency did in implementing is they changed their interpretation of the hospice cap statute that had been interpreted in an implementing regulation and in the Medicare benefit policy manual. And the instructions that it issued
Where had they
contractors.
Where had they previously interpreted how the aggregate cap worked in conjunction with the Budget Control Act or sequestration requirement? Where had they previously done that?
They had not, Your Honor, not to that level of specificity, but they did interpret the hospice cap as applying to total actual Medicare payments, which is the net reimbursement in each hospice's provider's statistical and reimbursement report. And the new interpretation changes that broad understanding of the hospice cap statute, and that was a change that required notice under 1395H8. Thank you.
Thank you. Go ahead, counsel. I mean, Judge Pillard.
I was just going to confirm that I think the point is that there would be an incentive to very slightly exceed the cap because on the delta of services provided above, in case A, above 980 would in that instance not be effectively capped. So it's an incentive, I think, counsel, for the government said to sort of skate right above, edge right above the cap. And it's a precision type of incentive, but an incentive nonetheless, in her view.
Or anything further? Thank you. Thank you, counsel.
Thank you, Your Honor.
We'll take the case under advisement.
Case number 20-1421, Coalition of MISO Transmission Customers et al., petitioners versus Federal Energy Regulatory Commission. Mr. Engelman for the petitioners, Mr. Glover for the respondents, Mr. Supino for the interveners.
Thank you. Counsel for petitioners.
Good morning. I'd like to reserve 2 minutes for rebuttal. Michael Engelman for petitioners, the Coalition of MISO Transmission Customers, the Industrial Energy Consumers of America, and LS Power Mid-Continent. The petitioners, two organizations that represent large consumers of energy in the Mid-Continent region, which is a 15-state region, and a MISO-approved qualified transmission developer, filed a complaint under Section 206 of the Federal Power Act, challenging the continued justness and reasonableness of a cost allocation provision in the Mid-Continent region that prohibits regional cost accountability for baseline reliability projects. The prohibition on regional cost accountability flies in the face of longstanding cost causation principles. To support their complaint, the petitioners provided an analysis of 29 of those baseline reliability projects planned between 2013, when the prohibition on regional cost accountability was implemented, through 2018.
Before you get into that information, can I ask you a predicate question about standing? And that is, does your coalition or the industrial and energy consumers, do they have members in each of MISO's 24 pricing zones?
They do. That's set forth on JA 29 through 31. The Coalition of MISO Transmission Customers.
Hang on, let me catch up to you. JA 29 through 31. Okay, and that shows that you have it. That says specifically that you have it in you have members in every zone.
It says we have members throughout MISO.
Okay, and you mean by that in each zone? In
each zone, exactly.
Well, that's two different statements, is it not? Throughout and each.
Well,
I mean, specificity is key here.
Specificity can be key in a standing argument. But in this case, the petitioners filed a complaint under Section 206 of the Federal Power Act. And what they set forth was that they are harmed by the cost allocation provisions in MISO. They set forth for the coalition that their members are spread throughout MISO, that they use 8 billion kilowatt hours of electricity per year. And the industrial energy consumers set forth that they also, their members are throughout MISO, that their members use 34% of the electricity consumed in MISO at a cost of $22 billion.
Okay, council, large numbers is not the same. That's what we're trying to get at. And maybe
Yes.
you didn't offer that or your clients didn't offer it.
Well, what we did offer is that
You're big, you're in the region, where?
throughout
And how specifically? And that's what we're looking for. I mean, I understand you file a 206 complaint. You don't like the fact that these projects are not subject to competition. I understand that as a general objection.
Sure. And what the petitioners put forth again is that they are throughout the region. Did we specify that we're in each pricing zone? No, but what we provided were examples throughout each part of MISO. And what we set forth was that the petitioners were throughout MISO and include a non-incumbent transmission developer, which we'll get to in a minute.
But let me
But Sierra Club, sorry.
No, you should finish your sentence. I'm sorry.
What Sierra Club says that is in most cases, the petitioner's standing to seek a review of administrative action is self-evident. And if the complainant is the object of the action or inaction at issue, as is the case usually in the review of a rulemaking and nearly always in the review of an adjudication, there is little question that the action or inaction caused injury. In this case,
we're raising it, and we do that often, all right? Because that's not an issue under Article 3 before the agency. And we've made it very clear in Sierra Club that if there is any question, and you acknowledge you haven't said in every. So that's all we're trying to get at, counsel. You file a complaint, you don't like the way the operator is limiting projects.
But Your Honor's question presumes that in order for the provision that we challenge to be unjust and unreasonable, we would have to show that we're in every transmission pricing zone rather than.
It presumes that the Supreme Court's Clapper decision means what it says.
And the Clapper decision referred to an objectively reasonably likelihood of harm, of imminent harm. And what, I'm sorry.
The petitioner is subject. I'm trying to get this distinction clear.
And there's
in my own mind.
I apologize
for interrupting. You can help me, not simply by repeating throughout and things like that.
Yeah. The imminent harm is the cost allocation provisions are applied on a project by project basis. And they prohibit the allocation of cost to anybody outside the zone in which a particular project is located.
That's the LSP harm, but just backing up to the consumer's harm.
Wait, I thought that was the consumer harm.
That's the consumer harm.
Right.
The LS,
okay, so part of it is
harm,
you're saying more competition will necessarily lower prices, and it'll be felt that way. So it's piggybacking on the harm to LSP as a non-incumbent developer.
It is in part, but it's not exclusively, because what the petitioner said is their members are harmed each time there's an improper cost allocation.
Right, and that's what I was trying to go back to, and just clarify that even the notion that there are members in every zone, I'm not sure establishes harm, because maybe more of the energy consumed is consumed in zones where there's benefit but not price imposition for the development. And that's the kind of thing that typically we see in a declaration when a case comes by petition to us, is something that really points to here's where we are, and maybe we're inside of a zone where the benefits of the project are felt outside, but we're shouldering all the cost. We just don't know from the record before us where the big consumers in your client's coalition and organization are, and therefore sort of the chapter and verse that supports the theory that the local pricing zone method, more than the line outage method, is going to burden them. It may be, depending on where they're located, that they actually are some of the people who get a free ride.
And Your Honor, that's exactly the point that we made in asserting our standing to challenge the cost allocation rules.
In general
because
terms, but not by identifying, here's a consumer, here's where they're located, this is outside, this project restricts cost recovery, or it's inside a pricing zone, and the cost recovery is overburdening consumers within the zone. There's nothing, not even one explanation that's at that level of specificity. And so I think that's, I mean, theoretically, I understand your point. It's quite clear, but for purposes of that kind of standing, I'm not sure we have the information we need.
Well, and we very much tried to provide you the information that was needed. Both.
Well, and I thought you provided these studies that showed particular zones where they were really some up to like 60%, where they were, the benefits were 60% elsewhere. So you have in your information identified some zones, not all of which are even challenged by the information in front of us, that showed some pretty disproportionate allocation of benefits. And so by telling us that you have members in every zone, you have sort of ipso facto identify that you have members who are cross-subsidizing the provision of benefits to people, substantial benefits to people in other zones. So that information is in the record before us. It's just, it would have been helpful to have it all knit together in a declaration or something. But
Understood.
it's there in the record, right?
We believe it's there in the record. Mm-hmm. And going back to Judge Pillard's point, what we pointed out in regarding the individual allocations is that, and why a membership committee is the appropriate one to bring this, is because she's exactly right. Some members are harmed, some members are benefit, but the position that we've taken is that all members are harmed when there's improper cost allocation, because these members are very energy intensive and they compete on a lot of things, energy prices being one of them. In fact, the Industrial Energy Consumers of America refer to themselves as energy intensive industries that have trade issues with that. So we laid out that as a association, their reason to challenge this is that some members are harmed, some members are hurt, but everybody's harmed by inappropriate cost allocation.
Now, where in the record did you identify the members who are hurt?
Individual members, Your Honor.
Exactly.
We did not individual.
Right. We don't know who they are.
Are the individual members identified anywhere in the record?
The individual members are not identified in the record. They're identified as large industrial users, and the Coalition of MISO Transmission Customers is actually a MISO member. They participate in all the MISO meetings as a MISO member representing these end users.
Thank you. Anything further, though, that you'd like to point us to in the record other than these studies?
I want to point. Yeah, I want to point to the competition piece of standing. For standing, you only need to find one petitioner has standing. LS Power has identified that it's a qualified transmission developer. This cost allocation regime prohibits us from competing for any of these projects. Associated Gas and US Telecom both assert that competition is appropriate for standing. the infringement of competition.
Typically on this side where there's a challenge to being cut out of competition, the petitioner will identify a project that is within, for example, in this situation where MISO has some projects that it's treating as baseline reliability projects, that were it not treating those as local, LSP would bid on. There's nothing that specific in this record, is there? Identifying, here's a project. And I'm thinking, you've read our 2017 LS Power judgment, and if we apply that here, why isn't that equally fatal?
Because we identified 12 projects that we would have bid on, the 12 in the report that have significant benefits. And if the cost allocation allowed recognition of those benefits, those would have been competed.
Where can I find a statement such as a manager declaration or CEO declaration saying we would have bid on these ones that are erroneously treated as local rather than regional?
Again, we say that at JA 29 through 31. In JA 463 through 464, we refer to the results of competition, and one of the two projects that MISO competed, LS Power won. So we've been consistent throughout that we compete on all projects, and we've spent thousands of dollars to become qualified.
Where does it say in the record in a sworn affidavit that it competes on all projects? Council, you've given us percentages, et cetera. Maybe we should just hear from, do you want to say anything on the merits?
I absolutely want to say some things on the merits, Your Honor, if you want to hear them.
You're not providing us any specificity in the record, so I thought just so you have a chance to say what is not otherwise emphasized in your brief on the merits.
Yes, on the merits, FERC's dismissal order didn't actually take on the evidence. The 12 projects that were identified, they never took on the percentages of costs that were inappropriately allocated. They simply said, well, it's okay. It's still mostly. For example, the court has no knowledge, looking at JA 46 on project 12112, as to why it's just and reasonable to allocate $65 million to Entergy Louisiana, 100% of the project costs, for a project when the neighboring utilities, Clico and Lafayette, get 58% of the benefits.
Are you arguing the entire category has to fall because a subset of the projects don't primarily or have more than a de minimis effect outside or benefit outside the pricing zone? Is that your view? That, it seems, just sort of to analogize, it seems like a facial attack. You're not saying, look, there's a subset of these that needs to be treated in a different category. The relief you're asking for is that the whole category is arbitrary and capricious, right?
No, what we've asked for is that FERC set a just and reasonable rate that recognizes projects that have regional benefits.
So that is a yes answer to the judge's question, is it not?
Well, no, the Judge Pillar asked if we were taking on the whole category.
Well, how are you making it clear you're not?
We made it clear in our Section 206 request. We on part 2 of the Section 206, we suggested using the light outage distribution factor, but we also said that it's up to FERC. So these the projects that have significant regional benefits can be addressed without potentially addressing those projects that only have modest spillover of benefits, which is what FERC represented was going to be the case, and what the Seventh Circuit relied on in affirming FERC is that there would only be a modest spillover of benefits. When you look at the individual projects, what modest spillover of benefits means, could be open to debate. But for example, on one of the 2017 projects, there's a 0.005. That's a modest spillover of benefits. But there's also a 48% spillover benefits, which is not modest. So FERC can address all of that on the second part of the Section 206. What we've argued is an absolute prohibition on any regional cost allocation for baseline reliability projects is inappropriate. Now, where the line is drawn is the second step of the Section 206, which FERC never
Can I
got
ask you
to.
a question? Right. So FERC adopted sort of a categorical rule here. And let's imagine you had done a study. I know this isn't your study, and you had found one case where there was a misallocation of benefits. So they have a categorical rule. And you do a study and find one case where there's a 67% misallocation between benefits, 67% benefits, but they're not paying anything in that zone. The zone that is paying is only getting, say, the 33% of the benefits. Would that be enough to take down a categorical rule? Would that make the categorical rule unreasonable, or would you just have to have the ability to be able to challenge on a case-by-case basis?
Well, it was challenged. That example was challenged in PSE&D v FERC 989 Fed 3rd 10, where one project didn't fit the categorical analysis. A line out, not a line outage distribution factor. That's what we used here, but a DFAX analysis, a distribution factor analysis was used. Because of the particular type of project there, that analysis didn't properly allocate benefits to the beneficiaries. And so what FERC did in that case was make an exception in the category that says, well, for this type of project, if this type of project comes up in the future, we're going to implement a different cost allocation methodology.
Right, but it didn't otherwise take the categorical rule down. It simply said when you've identified either individually or by some sort of subset, some common factor, then we can adjust. But it didn't indict the entire categorical rule.
But and again, that was one instance. What we've produced here are 12 instances where the
12 out of how many?
Well, 400. But the point is
right.
that these I'm sorry, Your Honor.
It's my sorry. Maybe you're about to answer what your point is. What I'm trying to get to is how do we know when it's too many so that it indicts the categorical rule, as opposed to those are just situations where the categorical rule's pretty good, but there have to be sort of opportunities for as applied challenges.
I think in this case, it's an easy answer because the categorical rule is a prohibition on any regional cost allocation. So in the other case, it was just an application of the rule. But here we have an absolute prohibition on any regional cost allocation. And that's the portion of the rule that's inappropriate. And that's actually...
Go ahead.
I'm sorry. That's what the court, this court looked at in the, the other case that I wanted to mention, the Old Dominion case. In that case, there was an absolute prohibition on any regional cost allocation. And in that case, there were only two projects that the court focused on to find that they provided benefits beyond the local zone, and therefore took down a categorical exclusion. And that's the same thing that we have here. And in that case, just one other thing on the overlap of those cases. In that case, what the court looked at was the fact that the allocation methodology that the commission had approved as showing the just and reasonable beneficiaries was the one that was used to show that the categorical exclusion didn't work. And that's the same thing we did here. We used the line outage distribution factor methodology, which FERC had approved for MISO to use for years to show that the assumption that there would be only a modest spillover of benefits was inaccurate. And so therefore the absolute exclusion of any regional reliability was any regional cost allocation was inappropriate.
Although FERC had moved away from that methodology, and I know it didn't rely on that, on any criticism of that methodology in the order here, but there is something a little anomalous about using the prior methodology that appears to have been rejected as at least not worth the candle and perhaps measuring the wrong thing as a critique of the current rule.
Two things. Actually, it wasn't rejected. It was just in the
Right.
205 filing.
It was
replaced.
superseded. It was superseded.
But the bigger point is FERC hasn't moved away from it. If you look at paragraph 88 of the order, FERC relies on that very methodology to support that most of the time what it's required works. And that's the same methodology that it relied on in 2013 and the same methodology that it required MISO to file informational reports on. So FERC actually hasn't moved away from the methodology. And in fact, if you assert that the LODF methodology doesn't measure beneficiaries, then FERC's entire analysis for why it changed the cost allocation is out the window, because that is the entire basis on which it changed it, was that the LODF methodology measures beneficiaries. Most of those beneficiaries are local, and therefore it's appropriate to allocate all of the costs locally.
I take your point. It's a good point, but I also think it's saying, it measures beneficiaries. Maybe it over measures them. And even under that method, there's not a lot of, spillover effect, and therefore we're going to take a more categorical approach. But I take your point.
And again, Your Honor, the problem with a categorical approach is that for baseline reliability projects, they're individually cost allocated.
Well, so the question I have is, why are you not, again, and this is a standing point, but maybe also getting to this issue of sort of as applied versus facial, why are you not saying, look, here's a project that is on deck and it has benefits outside the pricing zone, and I want to compete for it. Like, there's nothing that concrete. And so it's just hard to know. I mean, one of the things that FERC says is these are hypothetical, and, are any of them embraced within a planning process that then you can step forward and say, we are ready, willing, and able to do this project, and it is representative of a broader problem. For standing purposes, that would be extraordinarily helpful. And in terms of highlighting the scope of remedy that you're seeking, also helpful, but that's not what you've done.
It's not what we've done for this reason. What we did was take projects over a number of years and show that this problem continues to happen. 3 projects in 2017, 2 in 2018, and ask for a change moving forward with 2019 so that those projects could be competed. The problem with focusing on individual projects is twofold. One is the project goes on. So even if we file a complaint that the cost allocation is wrong, the opportunity to compete has gone by the wayside. The project's been aside, it's moved on. The cost allocation may get fixed later on down the road, but the opportunity to compete has been lost. And the consumers are very adamant that the opportunity to compete is an important part of their complaint. At JA 670, or excuse me, 470, what the consumers noted was that competition just on the couple projects that's happened has brought them better results than 5 years of litigation on ROE. The ROE is
Counsel,
lower.
we understand.
I actually have a follow-up question, Judge Rogers. Is that okay?
Go ahead.
So I know that this was a 206 petition and not a challenge. There'd been an original challenge to the rule of the Seventh Circuit case. But we had a standing rule that said even when FERC adopts a categorical prohibition on competition, in order to petition, you have to identify a specific project. How would that work, since you only, in that situation, which is a little different from here, but in that situation, you only have 60 days to file your petition after FERC announces a rule with a categorical prohibition on competition? It seemed to me a rather difficult situation. You didn't have a category in our unpublished LSP case. We didn't have a categorical prohibition like this one. So it does seem to be a bit odd to say you've got 60 days to find a project where you can't challenge the rule at all.
And actually in LSP, one piece of that claim was a potential categorical exclusion down the road. for what are known
Well, that was
as
part of the problem there.
exactly.
Right, exactly. That's very different from this situation, though. I mean, I know we're not in the place, we're not doing the original challenge to the rule, but if we adopt a standing theory here, presumably would apply in that situation. And I think when you have categorical prohibition, like you said, that's what you're challenging here. We have to assume you're right on the merits at this stage for purposes of assessing standing. It'd be quite hard for someone to identify a project within 60 days. I should think. I mean, you tell me. I don't know. Maybe you can find them. I don't know.
Well, I think what we tried to do, Your Honor, is to identify 12 projects that have passed that would have fit the bill.
Right. Well, you were doing a longer period of time.
Right. But we asked for a change in 2019. Now, that part of the difficulty in Judge Pillard's question is filing a complaint is we don't have the models to know which ones have the big spillover of benefits. And so MISO, because they're now using this location-based cost allocation, doesn't release the models till after the fact to show which projects have the benefits that go beyond the zone. So we're going to be hamstrung to wait for the models. In our case, we put in the complaint that the models were supposed to be out in February. They didn't come out while we were litigating that complaint. So the ability—
Have they come out yet?
They have come out now.
But it was after, was it while it was still before FERC or after FERC? Or?
I do not believe it was while it was still before FERC.
Was it before you filed your petition here?
Sure, because the FERC case took a while.
So I guess the point in this area would be, would it not, that an affidavit spelling all this out of impossibility would have helped, but that's not here. And furthermore, these projects don't appear overnight. They take years of development. Your client is a big operator, probably knows what's coming on board for the next decade. And there are many ways to indicate that, you know, Project X is something we would want to compete for. That's what I don't understand, why that's impossible. And there's nothing in the record to say it is impossible.
And Your Honor, I at the risk of repeating myself, we've represented that by becoming qualified, by paying thousands of dollars to become qualified, by submitting hundreds and hundreds of pages of records to get qualified to compete on any project that MISO competes.
With all due respect, counsel, you know, this court is a lower court. So help us out in finding the sort of standing as the Supreme Court has tightened its standing requirements.
And we believe that we fully have met those requirements of Lujan. These are not someday intentions of Sierra Club.
Why don't we hear from counsel for respondent? Counsel for respondent.
Thank you, Your Honor. May it please the court, I'm Matthew Glover and I represent respondent, the Federal Energy Regulatory Commission. If it's all right with the court, I'd like to start with something that I think was in the middle of Mr. Engelman's discussion, where he was talking about challenging the category and providing evidence that there's only a modest spillover. The first point I'd make on that, which is actually technically jurisdictional, and maybe I didn't do a great job in the brief in pointing out that collateral attacks are jurisdictional, but in the 2013 and 2014 order and the 2014 rehearing order that culminated in the Seventh Circuit proceeding, parties, including LS Power, specifically argued that, and I hate to read, but I do think it's helpful to read from paragraph, I guess I've misplaced it, 521 of the 2013 order. The commission explained that protesters argued that because a portion of the costs of some baseline reliability projects were then, under the line outage method, being allocated to the pricing zones other than the pricing zone in which the project is located, some baseline reliability projects provide benefits outside of the zone, and thus the costs are not allocated roughly commensurate with the benefits under mid.
535 or 5? You said 523.
It's 521 of the 2013 order,
Okay.
which we cited in our brief, and I think we cite this part of it in our brief, maybe around 38. But the 2013 orders FERC citation is 142 FERC paragraph 61, 215. And I guess just the point is that parties there, including LS Power, had argued that the fact that there would be using the line outage method, any one project might have had their benefits spread between zones, showed that it wasn't just and reasonable and didn't comport with cost causation to switch to a categorical method. The commission was unequivocal. We disagree. The commission must demonstrate that there's an articulable, plausible reason to believe that costs will be allocated at least roughly commensurate with benefits. As we found above, they call them MISO there, but what we use, Mid-Continent, has presented convincing support for its claim that the pricing zone in which a baseline reliability project is located receives most of the benefits provided by that project, and therefore we find assigning all of the associated costs to that pricing zone results in an allocation of costs that's roughly commensurate to the distribution.
No, but I think what they're saying here is, look, now we've got experience and information, and you've got arguments on that. We've got experience and information, both in the number or the volume of projects, and there's debates about that, but sheer volume of projects where there's a misallocation in their view, plus something that was emphasized heavily to the Seventh Circuit is, don't worry, when there's something that's regional, it'll be called a multi-value project and they'll be able to compete. And there'll be these and these other sources. So there's these other things that didn't materialize. And in fact, you already knew hadn't materialized at the time you told the Seventh Circuit that, right? I mean, 3 or 4 years had passed by the time, 3 years, I guess, had passed by the time you told that to the Seventh Circuit, not you personally. FERC told that to the Seventh Circuit. I mean, the answer is we aren't going to have those projects because we already had a glut of things that had been pre-authorized. You knew that long before, knew that long before they assured the Seventh Circuit there'd be all these opportunities for competition.
So I think there's two parts to your question, going to the merits of their changed circumstances. The first is the evidence post the 2013 and 14 proceedings, and the second is the multi-value projects. If I might, I'll start with the evidence after the 2013-14 proceeding and then address the multi-value projects, unless you'd prefer that I start with multi-value.
Well, you were sort of trying to make this a collateral attack. And what I'm saying is that in two ways, they say it's not a collateral attack. And so I don't know if you want to, I'm not yet raising the question of the merits issues there, but simply that in fact, to the extent you were trying to raise collateral attack as a jurisdictional point, they've got two distinct arguments here. And I guess what I'm more interested in is why did FERC emphasize so heavily to the Seventh Circuit that don't worry, there's all these multi-value and other projects coming for which they'll be able to compete, when even by was it 2016 that argument was? You already knew about the glut of pre-authorized projects. You knew nothing was coming down the line. So why did they tell the Seventh Circuit that, if in fact the very reasons we're now told for there not being those multi-value projects were already known and long in existence at the time of the Seventh Circuit argument?
Understood, Your Honor. Starting with the collateral attack, I only meant that the argument that the existence of any project that would have cost sharing means that sort of the facial categorical attack is identical to the facial categorical attack they made there. As to the merits of a changed circumstances argument on the multi-value projects, I don't think the commission hid the existence of the $6.75 billion portfolio that I believe was approved in 2011. In fact, I think it's paragraph 502 of the 2013 order. The commission mentions that portfolio eliminated the need for 23 baseline reliability projects. Here in paragraph 89, the commission says, we predicted that there would be a lot of multi-value projects, and we credit Mid-Continent's explanation for why that hasn't occurred, which includes the large portfolio that was approved in 2011, and I understand is still being constructed or just being completed construction, but it also includes things like the change in natural gas pricing and the change in inputs and the retirement of some facilities. That affects the economics of whether it's
how much of that was known at the time of the Seventh Circuit case, and how much of it is since then?
I think at the time of the Seventh Circuit case,
the
portfolio was known, and in the Seventh Circuit case, and I'm not sure if we put it in our appellate filings, but it was certainly mentioned in the 2013 order. I believe it might have been the 2014 rehearing
right,
order.
but it wasn't what was emphasized to the Seventh Circuit at all.
Sure, that it eliminated the need for 23 baseline reliability projects during that period, and that was a period prior to the Mid-Continent South integration. So that elimination of 23 projects would have been a larger percentage of, say, the baseline reliability projects that were occurring per year back at that time. The Commission's broader point as to compliance with Order 1000, both in that proceeding and here, is that Order 1000 doesn't require you to have a category that would include reliability projects that you'll cost share that is always going to sort of displace baseline reliability projects. We predicted that it would displace them. That prediction hasn't played out, but in paragraph 89 here, we credited Mid-Continent's explanation for why there haven't been more multi-value projects.
I understand why you've done that now. I'm confused as to how the Seventh Circuit was led to believe and seemed quite assured in their decision and at oral argument that these other opportunities for competition were going to be there that never materialized. It seems a bit troubling. And it certainly precludes an argument about a collateral attack here now that they've got more information.
I don't think it would preclude an argument that categorically you can't eliminate cost sharing if only one project were to have cost sharing.
But they're not arguing if only one. They're not arguing if only one. Now there are debates about how many examples they've shown that are viable, but they're not saying, I asked in the prior argument if there's just one, but that's not their argument now. And I assume FERC would agree and even they don't say this is this case, but if it turned out that 50% of the projects had more than 50% misallocation between costs and benefits, that could be raised later and it wouldn't be considered a categorical attack, to say you just can't have your categorical rule when half the time it's wrong, right?
That would be, I think, evidence of changed circumstances. And if I might address the evidence of changed circumstances, they keep, noting that the Seventh Circuit described it as a modest spillover. And we discussed the statistics and the updated statistics in paragraph 30, page 32 to 33 of our brief. But, in preparing for argument, I realized it may have been more helpful for me to have put a chart in there that showed, because at the time of the 2013 order.
Well, it would have been helpful if FERC had put a chart in its decision, but it didn't. It's a little hard for you to do it for them, right?
Fair enough, Your Honor. But at the time of the 2013 decision that was looking at the planning cycles before that, FERC noted that 80% of the baseline reliability projects would have had 75% of their costs, because they were applying the line management, had 75% of their costs allocated locally. And in the informational filings that FERC required from Mid-Continent.
20% is a lot. 20% is a lot.
Well, so that's the spillover that the Seventh Circuit described as modest. It was 80% of projects having 25 or having 75% or more allocated locally. That, when the Seventh Circuit used modest, it was describing that, the statistics that we had and Mid-Continent had put before them were that, and that the second statistic from that time was that more than half of the projects had 90% or greater allocated.
I know,
locally.
but more than half could be 51%.
Understood. And that's why I want to point to the informational filings that Mid-Continent did in 2016 and 17 that we have in front of us in this record. Those showed that again, in 2013, the statistic was that 80% of projects would have 75% or more allocated.
Where does FERC rely on that in its decision?
At JA or paragraph 88, I think it's JA 532. The description of these updated informational filings, and I think it's 532, but I'm looking at a non-JA paginated paragraph 88. Yep, it showed that 80% of projects would have had 100% of their costs allocated locally. So at the time of the Seventh Circuit, or the evidence in the Seventh Circuit proceeding showed 80% of projects would have 75% allocated locally. The next 2 years, analyzing the 130 projects approved in those 2 years, 80% would have 100% allocated locally. Right. And then the second part of that statistic was that of the projects that would have been eligible for cost sharing at all, 93.9% or 46 of 49 would have retained 75% locally. So you went from retaining 75% locally for 80% of the projects to 93.9. Right. So if anything, the changed circumstances that those informational filings showed was that there was fewer projects having spillover and fewer projects having large percentages of spillover. So in terms of the changed circumstances, the record, here suggests.
Okay, but then they had their. So that's a very fair point. They had is it pronounced Terra report or is it Becerra?
I actually don't know. I've been calling it Becerra, but
do I see a nod for
have-
Terra over there? Or I'm going to call it the Terra report right now. If that's okay. I'll be correct. I'm happy to stand corrected. And all I got from FERC is that the meaning and findings are mixed. The sample of projects is highly selective. I don't know what that means other than people tend to do reports that show what it is they want it to show. And then that MISO makes compelling arguments, but doesn't identify which of the arguments it's adopting, only that MISO makes compelling arguments that it may contain significant errors. What am I supposed to do with that as a response to this evidence about the Terra report? That's pretty vague. And they can't be adopting all of MISO's arguments because MISO was saying just don't use the line method anyhow. And we know FERC has not let go of that yet. So I'm just not sure what to do with this.
Sorry, and I know I'm in the red light, but if it's okay with the court, I'll answer your question. I think that I guess stepping back, the point of this proceeding is that it's a Section 206 proceeding. And so the petitioners, coalition, et cetera, had the burden of showing that the circumstances had so changed since the 2013 and 14 proceedings and the Seventh Circuit's 2016 ruling that using the current local cost allocation, which was found to be just and reasonable, is no longer just and reasonable. So they had this significant burden of showing that what was just and reasonable a few years ago is no longer. They presented these 12 projects, as we noted, they looked at 31 total, I guess, and that was highly selective. 4 of those were not actually baseline reliability projects. And, I think the statement that the value and meaning of the Becerra report is mixed and Mid-Continent has contrary evidence is essentially to say you had a significant burden to show there were such changed circumstances that the current cost allocation is no longer just and reasonable.
But their evidence identified some projects that were, I think, 50, 60, and 65% of the costs were misallocated. And those weren't ones that MISO's other, more particularized arguments knocked out. Those ones were left standing, even with the so-called the information that the commission references here that MISO made. And I assume that commission's position isn't that 50, 60, 65% is a modest spillover.
The commission didn't address that. Again, the modest
Right,
spillover
it didn't
has to do
address
with the
those
number of
examples.
projects having spillover. But I think that the problem, and this goes back to the sort of, I believe it was Judge Pillar was asking whether it was an as-applied or facial attack. They're saying that using this model is unjust and unreasonable. And we had found that with those previous percentages of projects having spillover, it was still just and reasonable to switch to this model. And so identifying, I think you noted 3% or 3 projects, I'll say, identifying those 3 projects, given everything else in the record, the commission did not find that this report, the Terra or Becerra report, met their burden of showing what was just and reasonable merely a couple of years ago was no longer. And so they didn't challenge, this specific project is definitely going to have
could they?
massive-
That's what I want to clear up if I can, because they say, look, we're challenging the fact that you have a flat prohibition and that I guess their view would be that you should have something that wouldn't be such a flat prohibition. It would be more context specific. Does the commission agree? And I understand there's all kinds of arguments for why we want to have a more administrable upfront rule. Does the commission dispute that if someone were to come in and say, here's a project, and whatever method of measurement you want to use, guess what happens? It's off by 65%. That someone could bring that focus, that as applied challenge to that project, and FERC would entertain it? Or would it say, too bad, that's what categorical rules are for?
Your Honor, I think, obviously there might be issues in terms of standing, et cetera, but I think if you are a ratepayer currently paying the costs of some project and you allege that project was, grossly disproportionate, you would file a Section 206 proceeding and say, I'm a ratepayer, my current rates are.
I'm not asking what they would do. I'm asking whether FERC would recognize that as a valid challenge, or would they go, what part of categorical don't you understand?
I assume that the commission would entertain that, but I can't think of a specific case that involved that type of challenge, just sort of in my experience with the commission. So I
Because
don't want to.
then we have the problem of, if we're unsure whether they could do that, then this really does become an argument about whether you can have a that rigid a categorical rule, which certainly caused trouble for the commission in Old Dominion. So I know I go through all the distinctions on that case, but what happened there is you had a rule, something was swept in and it shouldn't have been. And the argument in my hypothetical is this project was swept in and it shouldn't have been because it's so misallocated. And it seems different if they have to show that if you treat them like we would, and this may be the wrong analogy, but sort of facial versus as applied challenges, then that's fine. That's one thing. But if the commission's categorical rule is, I don't care if it's misallocated 99% benefits, and you have customers identified with affidavits complaining and LS there with its paperwork ready to compete, we're going to say, tough luck, that's what a categorical rule means. Then I think that looks like a different categorical rule than maybe the one the Seventh Circuit thought it was looking at.
So I think a customer certainly can come forward and say the rates I am paying are not just and reasonable. And here is why. I'm paying the costs for this baseline reliability project in the zone that I live that occurs. But the benefits are outside, et cetera, et cetera. And then the commission would have to.
Why isn't that this case with the industrial consumers?
Because they haven't alleged, they're not seeking to change the cost allocation of any of those specific projects. I think the response I was giving to Judge Millett is if you were alleging your current rate was unjust and reasonable because this specific project that you are paying for, I think the hypothetical she gave me was a project where it was 99%, but you are a ratepayer for that specific project because I'll call it hypothetical project A. Let's say it's in the Excel zone. You said I'm in the Excel zone and I'm currently paying for it, right? It's not an old project I previously paid for the rates I'm currently paying for this project. And my current rate is unjust and unreasonable because I'm paying for this Excel project that really has 99% benefits elsewhere.
Is that even a workable way to do it, though? I mean, are the consumers or even someone who wants to compete going to have the information in a timely manner to challenge if there is a FERC authorization of that project? I'm not sure what the challenge is. You say they can't challenge the tariff writ large to the extent it includes this categorical rule. And so what would be timely? Can they bring that anytime they finally get the information at hand about how these things are misallocated?
I confess I don't know if the costs of these projects, particularly the more expensive ones, I assume are going to be cost allocated over a few years of rates. So I think you would have a window, but mid-continent.
Is it a timely window? I don't know what's the time. I mean, I don't want to be told that there's a solution here that doesn't actually exist in reality.
So I don't know sort of what the timeliness of that would be, but again, if you're challenging our categorical rule as a facial matter, you needed to show change circumstances.
I just want to accept that you're. I'm sorry. Can I just clarify this thing?
Yeah, absolutely.
You say as a facial matter that what the commission is adopting is this what we use as courts in other contexts between what they're saying now is, well, our categorical rule is facially valid. You can't show it's wrong. It's certainly right in many circumstances, maybe most is what the commission would say, did say most of the time it's right. But that never precludes an as applied challenge. And people could come in project by project and say, and I'm sure they'll fight about what the right number is for a misallocation. But let's say we'll just say that over 50%, that's hard to call them out of spillover. As to those projects and say, you can't apply the categorical rule to this project, just like you couldn't in Old Dominion. You can't do it here because it's causing the rates at this point for this project to be unjust and unreasonable. And the commission's not going to say money's fungible and you're paying for lots of things. Your rate reflects a lot of different factors all at once. No one has a rate just for one project. And we said it was categorical. And the hard thing about categorical lines is sometimes bad things fall within them. That's not the commission's view. They are of the view when you said facial that there could be an as applied challenge.
I assume, particularly as you laid out the hypothetical, again, the ratepayer is then currently paying some rate. And I don't think the commission would say, well, your rate includes a lot of things because this is a cost-based rate. So it would actually, I believe, specify like what you're paying for this project or the, not necessarily you, the individual transmission customer, but all transmission customers in that zone. So I do think that the rate structure would provide for that sort of as applied challenge. Again, the challenge here was to show that the commission's cost allocation methodology is no longer just and reasonable.
Let me ask a question about that. You agree that the current method only works most of the time, and you seem to take the position that that is good enough. In the reply, Mr. Engelman argues that cost causation it's permissible for cost causation to be imperfect to meet other policy objectives. That seems to be what the precedent allows. What was the other policy objective that FERC was identifying here in embracing this treatment of baseline reliability projects over the line outage?
I think I have a couple of responses to that. The first one is the commission, it was in the 2013 proceeding and 2014 proceeding, the commission was making the determination that local cost-based allocation for baseline reliability projects was just and reasonable. And I don't take the commission in the order, and I certainly didn't mean to say that local cost allocation is right most of the time. The commission said in the 2013 order and reiterated here that it had said in the 2013 order that because reliability concerns on local systems are what lead to or cause the burden to create baseline reliability projects, it thought local allocation of baseline reliability projects then was just and reasonable and continues to be just and reasonable. As to sort of the additional, I think, factors, which is the language from Carnegie Gas and for the 1992 case and a handful of other cases talking about when you can pick between different methodologies, that wouldn't have been at issue here because the question here was whether what had already been approved continued to be just and reasonable or whether new evidence showed that it wasn't. I think in looking at the 2013 and 2014 proceedings, I looked at the orders, the commission emphasized, and I guess we did note that Mid-Continent put similar evidence in here, that they put in evidence that it's a local transmission provider who is causing the need for a baseline reliability project. The project's fix is usually on one or a couple of their systems or lines that will be within their footprint. And so, they provided testimony here, which was similar to what they had said in the previous case, that local cost allocation, recognizes that the purpose of these projects is to solve a local reliability violation or a violation of the national standards that's occurring on a local or specific entity's units. But here we were being asked, have petitioners met their burden to show that the circumstances have so changed that what was just and reasonable a few years ago is no longer just and reasonable? And the commission said that they didn't meet their burden. And that's where the language Judge Millett and I were discussing about the Terra report being.
Right. What about the problem that FERC in the 2013, 2014 proceeding relied on the prospect that MEPs and MVPs would displace BRPs, but that just hasn't happened. I mean, we've seen a slew of these cases, and Mr. Engelman is in many, if not all of them, where there's sort of a calling out of the commission for in Order 1000 saying, we're going to do a lot more competition, and that's going to be good for ratepayers, that's going to bring prices down. And then it seems like almost everywhere we turn, whoops, no competition here, no competition there, no competition everywhere. Is there some way you can help us understand why this isn't just sort of undermining the premise? I mean, I appreciate the legal arguments in each individual case, but can you give us any sort of more big picture assurance about the situation?
Your Honor, I've been focused mostly on the baseline reliability projects. I know the companion case is going to talk about the exception for immediate need reliability projects, but I think FERC did note, at least here, as to competition, that I think it's footnote 254. And sorry, I don't have the JA page, but that in the orders, which you'll discuss in the next case, like they were lowering the voltage for market efficiency projects, which in theory will lead to more competitive projects. But as to the lack of multi-value projects and competition since the 2011 $6.5 billion portfolio that's still being put in, the commission said in, I believe it's paragraph 89 that, they credited Mid-Continent's explanations, which included the different fluctuating prices of gas, et cetera. And I know I've already discussed that and I'm into the red light, so I don't mean to sort of retread anything. But on the broader question, I'm not sure that I have anything from the record in this proceeding or that I've sort of delved deeply into that. I don't want to throw my colleague under the bus. She has more experience at the commission than I do. I think, and I know you had a case last week dealing with the immediate need reliability exception in the New England system. So I don't want to speak to issues in those cases.
All right.
And I apologize. I don't have a better answer.
No, that's all
Can I
right.
ask one more question then? Do you dispute that the coalition and industrial energy consumers have members in each MISO pricing zone?
I did not see that in the record.
I'm asking, but I should have thought FERC would know a lot about these folks by now, but maybe not. Maybe that's my fault. FERC wouldn't care, I guess.
So
didn't question.
I don't think that we know that from the record here. I think they describe the coalition describes itself as an ad hoc membership
They say
organization.
they have members throughout, and I think it maybe not be the most precise term, but and a literal reading of throughout means we've got them everywhere. That's what throughout means. We've got them everywhere. And so
Sorry.
you don't dispute that.
I don't dispute that they said throughout. When I read their complaint and looked at those pages 29 to 31, did not see them state that they have members in every single pricing zone. I didn't see them state we have members in the pricing zones that have been allocated, costs that we think were misallocated using the terror report. I didn't see them point to any of those sort of statements. They didn't provide a declaration or affidavit. This court in Delaware Department of Environmental Control 785 F 3rd 1, which we cite in our brief, not for this point, but has said, you'll even entertain or you have discretion to entertain a declaration with the reply brief. We raised an issue with their standing in our brief. They didn't come forward with these additional facts that you were discussing with Mr. Engelman. And so I just didn't see, and I haven't seen in the record, statements to the effect that they have parties everywhere, or that one of their members is over or underpaying. Consumers being interested in competition, it seems like a general interest, but I'm happy to answer other questions on standing,
Thank you,
but we're over
Counselor.
time. Okay,
All right.
thank you.
So why don't we hear from counsel for interveners? Counsel for interveners?
Yes, Your Honor. Can you hear me?
Yes, I can.
Thank you. Sorry, I had to switch over to my phone due to technical issues. May it please the court, my name is Christopher Cepino of the Mid-Continent Independent System Operator, MISO or Mid-Continent, speaking on behalf of the interveners for respondents. We're here today on petitioner's second attempt to compel MISO to use their preferred methodology, the line outage distribution factor, to allocate the cost of baseline reliability projects. They've completely failed to carry their burden of demonstrating that MISO's current methodology is unjust and unreasonable. Their argument is built entirely on a flawed LODF analysis performed by their expert witness that fails to distinguish between impacts and benefits and assumes its own conclusion, an argument that confuses the source of reliability obligation with the scope of the benefits provided from a BRP, and a mistaken belief that BRPs only remain local if there are also approved MVPs that they will have the opportunity.
You talk about the failure to distinguish impacts and benefits, but that's not a basis that the commission relied on in rejecting their 206 challenge here, right? I mean, in fact, as Mr. Engelman pointed out, the commission itself has relied on the line outage method as a sort of valid inquiry in various contexts, even after it replaced the method here. So those are, I guess, those are 2 points. One, they didn't rely on it, and two, is it really flawed in the way that you say for failing to distinguish impacts and benefits?
Thank you, Your Honor. Those are two questions. I'll try to answer each of those separately. First, the commission did recite in their order our arguments, and on paragraphs 86 through 88, while they did not state exactly which of the arguments they found persuasive, they indicated that the burden was not proven, and that they have not moved the ball from where we were in 2013. So you can read into, do they have to adopt every one of our arguments in order to say that the petitioners haven't proven their burden when they haven't proven their burden?
Well, how do we know which ones they've, I guess, sorry, just to follow up on that, I don't know how we know why the commission, we know why MISO didn't like the terror report. I don't know how we know why the commission didn't. It says they're mixed. Well, that means some things, mixed means there's some helpful things, there's some informative things. It doesn't mean it's all bad. It's mixed. So that's pretty vague. And then it says the sample of projects is highly selective. I don't even know what they mean by that. Expert reports always support that person's side. So I don't know if they just mean we don't look at expert reports that support that person's side. That would be, FERC would be out of business. So I don't know what that means. And then all it says is MISO makes some compelling arguments, but some, one, the attack on the methodology is one that the commission itself has never embraced. And I should think if it was going to embrace it, it would do it more specifically than this. And so I don't know how we know you have evidence that's put forward here. And if an agency says, well, it's mixed, it has, which I interpret as it has some important, helpful information and it has some not so good. And it's selective in that it supports their position. Is that really grappling with the evidence that's been put before it?
Yes, Your Honor, I believe that it is. If you look at paragraph 86 of the order on page 530 of the joint appendix, say that complainants have not demonstrated that the current BRP cost allocation methodology is unreasonable because the record isn't sufficient for us to conclude that the pricing zone does not receive the majority of the benefits. Our entire
It
argument
certainly is for a number of
majority-
examples. It certainly is for a number of examples in the report. Now we can argue about whether 4 is enough, 5 is enough, 12 is enough, but there certainly were some that definitely, absolutely did that with 65%, 60%, 50%. So I don't know what to make of that.
Your Honor, our position is that assumes the correctness of the LODF methodology. The commission
Well,
has
and
found
I
that
think
the
we have to assume that because FERC embraced it, FERC uses that in its position, it's used it repeatedly. And I know that MISO has its critiques of it, but it's hard. I don't know how we can read this opinion as FERC embracing that argument. Can we?
Your Honor, yes, you can, because if FERC embraces the arguments that the primary beneficiary, the primary benefit of these projects is to resolve the local reliability violation, LODF doesn't measure that. In fact, it completely ignores the ability of it completely ignores the requirement that the TO mitigate that constraint. I'm not aware of anywhere, in this proceeding or in 2013 where FERC or the commission or even Alice Power has argued, or the petitioners have argued, that a flow change in and of itself is a benefit. Definitionally, it is not. It's a flow change.
I understand your argument about that, but I don't know how I could say, we as a court could say that's what the commission meant. Because they rely on the line definition. I'm not using the right terminology, but they rely on that exact same test in their opinion. They've relied on it pretty consistently. So I don't know how we can say that. That might be what they meant, but they surely haven't said it.
Your Honor, I understand that viewpoint. Our view is that they have said that the primary benefit is resolving the local reliability violation. So if you say that that is the primary benefit, and that's one benefit, then the idea that an LODF analysis must supply an alternative is mistaken. But
you're saying
that, Your Honor,
there's no other way to read their decision, but it's absolutely 100% certain that's what they meant.
Your Honor, I can't say there's no other way to read their decision. However, what I can say is that there is reading that there is a reading of that, and the most sensible reading is that BRPs have not been shown to not be primarily to resolve local reliability violations. LODF method, has been used by the commission as both a proxy for determining benefits. It's never been asserted to, in and of itself, be benefits. But we don't see how it disturbs that conclusion. If the primary benefit are the transmission owner has to mitigate reliability constraints on its system, and the BRP is necessary to do that, what does the petitioner have to show in order to say that benefits are going outside of the zone? Bear in mind, Your Honor, that under the hierarchy that MISO has, any project that produces an actual regional economic benefit is going to be an MEP. If it produces regional,
Well, they say
regional
that
reliability.
their report says that hasn't happened. They identify a number of situations. Now, I'm not sure to say whether that's enough to throw out a categorical rule, but they say here's a number of situations where no one can with a straight face say it's modest spillover, 50, 60, 65%, things like that. They identify those. So, and they weren't treated as subject to, as market value or any other type of project that would subject it to competition. So saying that's just automatically going to happen, they've come forward with evidence that the commission has not indicted here. We don't have to read it as indicting. I'd be troubled. I would feel uncomfortable. I can't speak for anyone else adopting a reading that rejects a theory, a model in theory that they have used repeatedly. And the other arguments MISO makes just didn't touch those situations. So I don't think it's an answer to say that the rule works so that any time there's more than 50% of the benefits going to another zone, that it'll be treated as a regional project.
Your Honor, I would ask where in all of the complaints or in any of the proceedings below, do they show that there's any actual benefit, that there's any $1 of savings or $1 of extra expense based on any flow impact to any of these changes?
Okay, we use the model that FERC used. Can you tell me, maybe I'm going to try it another way. Can you tell me how many projects within MISO have been subject to competitive bidding since Order 1000 was issued?
Your
Do you
Honor,
have that statistics in there?
Yes, I believe we've had 2 projects that have been subject to competitive bidding. However, there would have been more projects except for that state right.
Okay, so I'm sorry, and that's over a decade now?
The
A
2
little
projects are broader than, let me just say, it's not just 2 discrete projects. Let me just be clear. Well, how are you going to finish your answer to Judge Millett?
Okay.
You
Thank
said
you, Your
there's
Honor.
2 projects, but there could have been more. But
yes, there could have been more. However, several states in the MISO footprint have right of first refusal laws that would take a project that might otherwise be non-competitive. So we had some that could have qualified for that, one in Minnesota, but was not eligible as a result of that.
Well, that was known at the time all these exceptions were adopted. So 2 in a decade?
Your Honor, I would submit that, 2 points. I would submit that there's no quota. If a BRP truly is a local project, there was
can
no
I clarify,
guarantee.
did you mean 2 BRPs or did you mean 2 projects at all? Of any category?
Sorry, Your Honor,
Sorry, now I want to make sure I understood your answer correctly. Maybe I misunderstood it. When I asked how many projects, were you telling me just baseline reliability projects or projects of any type?
Was your question, Your Honor, whether the projects were competitive or how many projects were competitive?
When I say project, I'm not talking just about baseline reliability. I'm talking about any projects. But there weren't multi-value projects. There weren't other things. So maybe there was some other category you know of.
Well, there's been 2 market efficiency projects or 3 market efficiency projects in that intervening time frame, 2 of which have actually been put out to competition, and one of which was actually won by one of the complainant's affiliates.
Okay, so that's separate from these 2. The 2 you were talking about were 2 baseline reliability projects.
No, market efficiency projects, Your Honor.
Okay, so have there been? Sorry, go ahead.
No,
I have a much more simplistic understanding of things than you do in this area, so I apologize. So my question had been how many projects, and I meant projects writ large, have been subject to competition, and the answer we got was 2. But then in light of Judge Rogers' question, I wanted to understand: did you mean only 2 baseline reliability projects have qualified for competition?
Sorry, Your Honor, there have been 2 projects that have been found eligible for competition in MISO, total.
And okay, total. But then you just said that there were 3 market efficiency projects. Did one of those fall victim to this? Is that one of those that fell victim to the state right of first refusal?
Yes.
Got it. Okay.
Yes, Your Honor.
All
All
right.
right. Anything further, counsel?
Do you know how many
yes, Your-
market efficiency and multi-value projects have been approved for the 2020 and 2021 MISO planning cycles?
Your Honor, that's actually one point that I did want to bring to the court's attention. MVPs move cyclically. We've invested about $6.5 billion in 2011 and 2012. All the BRPs combined in that time are only about 5.3 billion. MISO just filed last week with the commission a proposal that is intended to help produce the next tranche of projects that we hope will be MVPs. And that's the LRTP initiative. And that filing was, if I can look for a second and see where that filing was made, in docket ER 22-995. But the point that I'm making with that,
and I don't mean to mix up category cases here, but will any of those that are proposed qualify as immediate need reliability projects?
it's too soon to say, Your Honor. However, these are still proceeding through the stakeholder process.
Mm-hmm.
But the point that I wanted to illustrate with that is that these projects move in cycles. MISO does not build $6 billion in projects and then 3 years later build another few billion. These are large portfolios. So yes, there's plenty of testimony in the underlying record about why these cycles may have been pushed out a bit longer due to lower gas prices and other industry developments. But we still do expect that there will be more MVPs. Regardless, there's not a quota. It's not appropriate simply because they want more projects to compete on to take something that isn't regional.
Do you know how many projects total have been approved since Order 1000 within MISO? So we got 2 subject to competition. 2. What's the denominator there? Out of
to a ballpark, Honor, but I believe that it is somewhere in the neighborhood of. I believe it is somewhere in the neighborhood of 500.
2 out of 500. Okay, ballparking it. Okay, great. Thank you.
Thank you,
Your Honor.
counsel. All right, counsel for petitioners.
Thank you, Your Honor. And Judge Millett, if you look at JA 49 and 50.
Sorry, your line's crackling up a little bit here. Did you say 49 and 50?
49 and 50 is a list of projects in MISO that have occurred since 2010. So we'll answer all of your questions about the number of projects. Mr. Cepino is right. Only 2 have been competed. He is wrong about the number. For example, there were 310 other projects in 2019 alone at $2.8 billion. 2019 was the year that we wanted to challenge the going forward application of baseline reliability not having regional benefits. There were 113 projects that year at $836 million. So there's quite the list here, and you are correct that 2 have been competed. I want to touch on something Mr. Cepino said because he made a very strong argument that nobody has ever equated impacts with benefits. If you will look at at JA 404, we quote the commission in its 2013 order saying the following, quote, MISO explains that LODF analysis identifies the beneficiaries of a baseline reliability project based on the impact. That's exactly what we put forth. And Your Honor, Judge Millett, I think what you've identified is the problem with this case. FERC hasn't addressed the actual substance of what we put forth. They simply made a conclusory analysis that we didn't meet the requirements we didn't meet our burden of proof. And Mr. Glover would have you believe that their analysis back in 2013 was that there were going to be these kinds of projects with 50, 60, or 70%, because he says we didn't meet the burden of showing changed circumstances. That can't be what the commission meant then. There's nothing in the record to suggest that the commission meant in 2013 when they allowed this order or allowed the elimination of regional allocation, that there were going to be 40, 50, 60% of the benefits. And what we've asked is that the court send it back to the commission to actually answer all of these questions. And we think we've met the standing requirements through the various standing cases to have that outcome, that the court sends it back to the commission to answer these questions. Why is it appropriate to allow 50 or 60 or 70% of the benefits to go to a zone that's not getting any of the cost? And on the
All right. Anything further, counsel?
Can I ask you what your denominator is, 2 out of?
I could give you the answer, but unfortunately we didn't add it up on 40, 49 and 50. But I believe the denominator, when you include other projects, which are a separate category.
Yeah, I said all projects. So I thought, I thought everything.
All projects, I believe the denominator will be in a couple thousand.
Okay.
Your best standing case is Sierra Club, or what's your best case that you have shown enough concretely harm?
Yeah, it's Sierra Club that we've established sufficient harm for the associations to show that their members are harmed both by improper cost allocation, some benefited, some harmed by improper cost allocation, and by the lack of competition.
Even though you never identified them or where they are, anything like that. I mean, counsel, that's not what Sierra Club is getting at. All right. If you had identified, then it might be self-evident, but it's not self-evident.
Well, we
That's the problem. And where it isn't self-evident, Sierra Club said, file an affidavit with your opening brief. And this court has gone along to say, well, you know, if it isn't crystal clear, we'll let you do it in a reply brief as well. But in any event, so Sierra Club is what you're relying on, right?
It is. And then on the competition piece, I just want to add on JA 48 or 46, footnotes 67 and 68. Those show the amount that the cost is increased on those projects.
Yep.
Because they weren't subject to competition, there's no cost caps or any other thing on those.
Now, is anybody harmed? Imminent harm.
Ratepayers are harmed, which Mr. Glover said acknowledged was an actual harm.
All right.
And
well,
all of our clients are ratepayers.
On the same points, aren't we, counsel? We're trying to get you to get us within the Supreme Court, and maybe my colleagues will say you've done enough. All right, but I think we have your argument. Anything new?
No, thank you, Your Honor, for hearing us.
Thank you. Thank you, counsel. We'll take the case under advisement.
Case number 20-1465 et al. LSP Transmission Holdings II, LLC et al. Petitioners versus Federal Energy Regulatory Commission. Mr. Fallon for the petitioners, Ms. Chu for the respondents, Ms. Valley for the interveners.
Counsel for petitioners, please proceed.
Thank you, Your Honor. In the orders under review, the Federal Energy Regulatory Commission violated the bedrock rate-making principle of cost causation. By doing so, FERC foreclosed competition for certain regionally beneficial projects between 100 and 229 kV. Because if the commission would have applied this bedrock rate-making principle, cost causation, matching the benefits of the project to who's paying the cost, these projects could and likely would have been competed. Petitioners asked that the court remand the orders under review for FERC to determine whether the just and reasonable rate for a market efficiency project in MISO should be between 100 and 229 kV. Now, petitioners in this case had a very easy ask. We simply asked, please don't foreclose us from competing from certain projects, for competing for certain projects, 100 to 229 kV projects that were economic, that would have to be economic. We weren't asking, there was really no harm from our ask. We weren't asking that these projects automatically be market efficiency projects. Those projects would still have to meet the 1 to 25 benefit to cost ratio. Moreover, in order to be competed, those projects would still have to show that more than one zone in MISO benefited from the project, the zone where the project is physically located and one other zone. And I think this is important. This is a very important case, a very important fact. There are no rate feasibility. When we asked FERC and MISO to calculate the benefits, that wasn't some Herculean ask that the petitioners were asking. There are no rate feasibility concerns that have been raised in this case. Certainly FERC didn't say any. And the reason why they didn't is because they'll know the zones that benefit from the project by the analysis that they do to determine whether the project is economic. And I would direct the court's attention generally.
When you say no rate feasibility concerns, you mean there's no difficulty calculating for the benefits? That's what you mean by rate feasibility?
Yes, Your Honor. Yes, Your Honor. Yes, thank you. And so I direct the court generally to JA 866 to 872, which has a very good discussion of the MISO planning process, specifically as it relates to congestion. And in 870, the MISO over 5 planning cycles identified 15 projects that were quote unquote economic. And now I would direct the court to JA 309.
And you mean by, sorry, I'm having, there's a lot of words in the cases. By economic, you mean?
I mean that they meet the 1 to 25 benefit to cost ratio.
Okay.
That they have showed that the benefits of the project are 25% greater than the cost.
Okay. All right. That's good.
And so if you look at JA 309, the MISO has a project. They have a project. They have benefit metrics. We've been talking about 3 of them in this case. They have benefit metrics. They apply the benefit metrics to the project. They look at the benefits by zone. They add up the benefits by zone. And if the benefits are more than 1 to 25, the benefits of the project are 25% greater than the cost, then the project is quote unquote economic. So in doing that analysis, they know the zones that benefit. And the reason why we're sitting here in front of you all today is because the FERC ignored that for purposes of cost allocation and ultimately for competing these projects, because FERC rejected our very simple ask. FERC said, we're not going to let you compete. We're not going to let you compete. You didn't show the 345 kV and the existing 345 kV and below kV threshold is unjust and unreasonable. We're not going to let you compete. So we're going to keep these projects in the other project bucket. We're going to keep them there. And because the projects are in the quote unquote other project bucket, the costs are automatically allocated to the zone where the project is physically located. And so these projects they're not going to be competed, even though they know the beneficiaries. They can easily determine the beneficiaries. Again, Your Honor, there's no rate feasibility concerns here, the inability to calculate the benefits. And
but isn't the point, Mr. Fallon, that when they to do that over this category of projects in general, they might discern some non-pricing zone effects, but they're willing to say that in the aggregate on balance, not enough to impugn the category. And so they think that this is actually an appropriate treatment of the category of projects.
Your Honor, I think what we're saying is that they know the beneficiaries. They know the beneficiaries. What they do is they put it in the category and they never apply the beneficiaries. And Your Honor, if they did say that, well, there's just maybe a few or whatever, that's belied by the record in the case below concerning things like the Northern Indiana case and the like, and the fact that most congestion in the MISO is between 100 and 229 kV and the like. So if the FERC is saying that, that's sort of belied by the record. Is that responsive to your question, Your Honor?
I'm not sure it is, but you go ahead.
So FERC also said, look, even for the projects we're going to let you compete, the 230 and kV above, we're going to let you compete on those projects. We're not going to let you compete if there's a quote unquote immediate need. And if you look again at JA 870, in JA 870, there's been 15 of these projects, 6 of which were 230 kV and above. So there's been approximately 1 per cycle. The MISO said at JA 320 that approximately 1 project each cycle will be part of this exemption. And so even for the projects that they did allow us to compete on, the immediate need exception they granted would foreclose likely that project. We believe there's likely an 85% chance, because most projects are needed within 3 years or less, an 85% chance that the project won't be competing, even for the ones.
Where is your evidence that within MISO that 85% of these immediate need, these projects which you could compete will be treated as immediate need? Because that seems to be pretty critical to your attack.
It was in our brief, Your Honor. We analyzed. I think we got those figures, Your Honor, from the MISO and their analysis. I mean, I think that's their figures, and it's cited in our brief.
Okay. So the 85% of all the projects, these market efficiency projects, will be subject to the immediate need exception.
85%, Your Honor. I think the figure is 85% of all projects, and that was one of their debates, is that we had the wrong sort of, we were mixing apples and oranges. But I think our view is 85% of the time the project would be needed, quote unquote, needed within 3 years. And so if that project is bundled with a market efficiency project, then the project will more than likely.
Sorry, when you say what's needed, you're talking like a baseline reliability project that's going to be needed within 3 years. And then when it ends up having the other criteria that qualify it as a market efficiency project.
No, this would be generally a project, and I don't think we were talking here about baseline reliability projects.
Okay.
We were talking generally about projects that are solving a reliability violation.
Well, that's what I'm trying to figure out, is just, and so whether it's other projects category or baseline reliability, is your point that, or I guess where is the evidence? It would make sense to me that reliability projects are something that we want to have addressed quickly. And so to the extent market efficiency projects are covering those, then, but I don't know that information. And I was, I can't, I have to give FERC some credit saying that you weren't showing, or you hadn't shown, and maybe you tell me why I'm wrong about this, that 85% of reliability projects in MISO are supposed to be done within 3 years.
Well, what they look at is a very conservative planning model that the project is quote unquote needed within 3 years, even though I think we've said that the project won't be built more than likely within 3 years. And so they'll use other techniques to, the in-service date for these projects would be more than 3 years. And so they're using a very conservative planning model. So it's not surprising that based on their very conservative planning model, 80% of the 5% of the projects are quote unquote needed within 3 years.
Can I just back up and ask you about standing and whether you've identified any project under the MISO tariff that you would compete for if the KV threshold were lower, but are barred from because MISO stopped at 230 kV rather than going to the 100 kV that you prefer?
Well, Your Honor, there have been from the 2018 Market Transmission Efficiency Plan, the MISO plan, there were 2 projects that could have been competed, but they weren't because of the 100 to 229 kV threshold.
And where did you identify that those were projects that your clients would bid on?
Your Honor, my client would bid on a project if it has the opportunity.
Where in the record does your client say we would bid on this project or all projects like it? No declaration?
No, Your Honor, there wasn't a declaration.
I cut you off. You started to say my client would bid on all.
My client would, if given the opportunity to compete, my client would bid on projects, would bid on projects with the opportunity to compete. And that's why I think but you're right, Your Honor, there was no declaration, but our client has won one of these competitive solicitations before, has competed and won, therefore, for those things. We would more than likely compete on these projects in the future. We don't have the right. They immediately have stopped us from competing for these projects. And that's why we go back and look at the Shirley case, which is what was cited by the FERC, the MISO in their brief. And they said, and the court said there, we see no reason anyone competing for a government benefit should not be able to assert competitor standing when the government takes a step that benefits his rival and therefore injures him economically. That's exactly what happened in this case, Your Honor. They took projects between 100 and 229 kV, and they're handing those projects to our competitors, the incumbent transmission owners, to build these projects. And so they're doing that. They're going to do that. They're handing our competitors and frustrating our ability to compete for these projects.
Would you have been able to identify a specific project within 60 days of when the commission issued its decision?
I'm sorry, Your Honor, I didn't hear that question.
So you had to file within 60 days of the commission's decision, right?
Yes.
Would that have been enough time to identify specific projects as to which you would be harmed by the rule?
Well, certainly the MISO.
There's a categorical rule that's your argument. It's like we're categorically walled off here, but would you even have been able to identify something that quickly, or is it the nature of categorical rules you can't?
Well, obviously the MISO is going through its planning process now. The projects that have already happened, it's really too late in that process. I think the idea that, we would wait and somehow file a complaint if we have benefits and this kind of discussion, I don't think that works, because in the meantime, while the FERC process, the appellate process is going on, the projects are moving forward. I don't really know, Your Honor, within that 60-day window, if we could have identified a couple of projects or a project in the most recent transmission planning program that was going through. I really don't know if that was the case.
I'm just trying to figure out how this even works. So someone submits a project to MISO, we want to build this. We think it's immediate need, or we think it qualifies as market efficiency projects. No, I don't want that. So we want to build a project either that's going to be under 230 volts or it's an immediate need one. and you want to compete, what time window do you have to say, and then FERC at some point must say, you can treat it that way. It qualifies for that treatment. When is the time window when you could come in and say, hang on, we should be able to compete for that project? I just don't know how the process works.
I think, Your Honor, this is all a MISO-driven process. Once FERC sets the rules, I don't think FERC is getting involved. Maybe Ms. Valley can comment on that, but I don't think FERC is getting involved in the individual projects that are approved as part of the plan. And so what would happen in this situation is the MISO board approves a transmission expansion plan. We say, hey, there's more than one zone that benefit. This project ought to be competed. We would then have to go to FERC and file a complaint, and then FERC would have to act on that complaint. You can probably count on.
Once you do that, does that stop?
No.
MISO from going? That's why I'm trying to figure out how the time works.
Absolutely not, Your Honor. The projects continue to roll on, if you would, and the projects continue to roll on. There's no stay. There's no.
Right. So how long does it take for, since if they're not competition, so the local utility is going to be the one that's going to build this. And so how long does it take between when they submit their sort of public notice, MISO submits this plan, here's our plan for 2022 to FERC, before the local construction folks that are your competitors, the local developers, start sort of shovels in the ground? You have their time for a FERC challenge and going to court? Or?
I really don't know, Your Honor. I would think that these projects, to the extent they're built, would happen within a year. But I really don't know, Your Honor. I really don't know that.
Okay.
I would think they would happen within a year, maybe a year and a half after the approval. Obviously, you may have to get some local permits. You may have to, go see this environmental agency and the like. But I do think, Your Honor, the situation here that is possibly being discussed is similar to what the court has dealt with in the pipeline cases, in the natural gas pipeline cases, where the commission was giving people certificates, they were out building, and then people were working their way through the FERC and appellate process. And then by the time the court acted and said, hey, there's a problem here, the project was already in the ground, and the court just dealt with that issue in the Environmental Defense Fund case. And so
we've had other cases where the project has stopped. Have you, on behalf of your clients, filed a motion to stay in a particular project?
No, Your Honor, but we don't believe that FERC would grant the stay.
Well,
maybe they might. Maybe they might.
Who knows?
Who knows?
There may be public opposition. There may be opposition enough that FERC says we need to. So that's all speculation. All right.
Well, it's hard. It's surely hard to show a likelihood of success.
That these projects, which are not tiny and well known, and your client can identify, and you say FERC knows all this, but you're supposed to let the court know. It's your burden, all right, to show you have standing. And we need to know. Whatever FERC knows is interesting, but it's your burden, all right? And FERC doesn't have to help you meet your burden in that regard. Secondly, I'm just not clear why, where your clients have all this information, you can't, and if you don't have the information, ask FERC to provide it. Why these cases can't be teed up with more specificity. I understand it's timely, it's costly, but there's a lot at stake. And reliability is something that the agency has decided is paramount in the projects that it has identified. Now, it may be wrong, but it seems to me in order to get to that, there's a hurdle that Article 3 sets for the court. And I'm just not understanding why experienced counsel, at least when they come to this circuit, know that standing is a heavy threshold demonstration. And simply a good legal argument at that point is not enough.
Your Honor, I think there are two separate issues here. We'll talk about the standing, but there were two separate issues. There was the immediate need, and then there was the 100 to 229 kV.
That's, with all due respect, FERC statement at least explains its explanation of why everything isn't operational within 3 years. All right, and you haven't attacked that as a practical matter. Secondly, being barred from a category. But don't you have some obligation to assure the court that either because your clients are big or because of where they're located, this is precisely the project on which they would want to build or compete? I don't understand why your clients can't provide this information. That's all I'm getting at. No one's argued it's impossible to provide it. You say FERC has it, well, ask them to give you that information. And if they turn you down, then you're in a different situation.
Your Honor, I think FERC has, what we've said in terms of competitor standing is, we compete all over the country for projects.
Right, and we don't really have to concern ourselves with what you do all over the country.
Well, that's right, Your Honor. And
all
we
right,
also,
so you know that, counsel. So you're coming to the DC circuit, and you know that no matter what panel you're before, you're going to get questions on standing, specificity, eminence. And I don't understand why everybody's not prepared on this. I mean, we don't have any authority to overrule the Supreme Court.
Your Honor, I think in the earlier discussion I did listen in on, in our case, though, what we're saying is, what FERC did is it provided a benefit to our competitors, and we are harmed economically. We did compete on one project. These projects are ongoing. They're ongoing projects. They're going to continue to identify economic projects between 100 and 229 kV. They're going to continue to foreclose us from bidding on those projects if we were so inclined to bid on those projects, and I can't consider it.
If I don't understand why we can't get some declarations in here where people say, look, we bid before, this is profitable for us, we want to do it again. Now there's a project that FERC has in the pipeline or that one of our competitors has in the pipeline. And that's precisely why we want to bid on it. And FERC is saying no. And you're saying, well, by putting all these into the immediate need category, that's a complete miscategorization because these projects are not operational within 3 years.
Your Honor, I think we're saying two things on that. The immediate need exception was a separate issue that we briefed, but the other issue is that the projects between 100 that they did let us compete on, the immediate need for the 230 kV above, and for the projects 100 to 229 kV above, they foreclosed us from participating in these projects. Your Honor, and I'm not arguing with Your Honor, please.
Well, all you said here today is your clients might someday want to bid on these projects.
Well,
all
Your
right?
Honor,
You haven't said, and it seems to me your clients have the information, or if they don't, they ask FERC for it. I mean, the court is not trying to arbitrarily reject petitions on standing grounds, but we're simply looking for the hard information. And these projects are years in the development. Most of the lawyers who come before us are representing, quote, large actors. They know what's going on. This is not some stranger to the industry, much less stranger to the region. And I don't understand why, given you're as familiar with the Supreme Court decisions on standing as we, and presumably how tough it is in this circuit as compared to some other circuits to show Article 3 standing. So why not come prepared with affidavits, declarations, etc.? In other cases, once the Supreme Court started to ratchet up the standing requirements, industry has come in with very specific information that they didn't used to. And it's unclear to me why. And it's also unclear to me why, and I know it may just be money. They don't want to spend the money to ask FERC to stay. There may be some competitive disadvantage on other projects, and so they don't want. But these are choices they make. And when the court has this heavy burden, we need help.
Your Honor, it sounds like Your Honor is, our view was this was a category exclusion, the 100 to 229 kV.
I know, and all we know is the lawyer has told us that the people he represents or the entities he represents may one day want to bid. You're not making any commitment. You're not having any declaration. And goodness knows the Supreme Court has talked about these someday intentions are not enough. That's all I'm getting at. This is not this court coming up with some arbitrary rules, and it's not the Supreme Court. It's the Supreme Court interpreting this Constitution.
I understand, Your Honor. I understand.
Anything further? Shall we hear from the agency and then from interveners and then give you some time on rebuttal?
Yes, Your Honor. I had 3 minutes on rebuttal.
Counsel for respondent.
May it please the court, Susanna Chu for the commission. Thank you for hearing these cases today. I'd like to start with the timing and specificity questions that your honors have raised. There is nothing that prevented LS Power from submitting an affidavit about any project that was selected in the transmission planning processes of 2018, 2019, or any of these recent years, showing that they had the ability to bid on a specific project, but were precluded from doing so because of the way that Mid-Continent categorizes its projects.
Well, I think the argument is, look, these are big operators that bid before. They have the ability to bid. All right. I don't think that's the question, is it?
Well, I think it's part of the question, Your Honor. I think the question is whether they
these aren't
could have and would have bid.
For small operators. At least that's the representation that counsel's making on their behalf. So I don't know that it's ability, because that's not where the Supreme Court has focused. I mean, that's where we talk about, ready, willing, and able. But that's not the issue at this stage. It's an imminence issue, as I see it.
Yes, I think that's right, Your Honor. It's an imminence issue under Clapper, under New York Regional Interconnect, and all the other precedents. This case is very similar to the unpublished decision involving LS Power from 2017. As Your Honor is pointing out, LS Power may one day want to bid on a project in the Mid-Continent region.
Wait a minute.
But they haven't pointed out any specific project.
Sorry, can I ask something? So imagine I own, it's a women's owned construction business situated within MISO, or I have at least a branch within MISO. I have in the past bid on projects in MISO or wanted to bid. I have expressed my interest in continuing to bid. And FERC, I'm not saying they would, this is just hypothetical. FERC adopts a rule that says categorically, no women-owned construction companies can compete for X category of contracts. Right? FERC adopts that rule. This is not your FERC, this is bad FERC somewhere, FERC X somewhere. Not suggesting.
Understood, Your Honor.
Women-owned companies cannot compete for X category of contracts within MISO. Categorically. And your position is that to establish standing, I have to wait for a specific project to come along, which will be more than 60 days after that order has issued from FERC. And I then have to bid for this thing that I'm categorically forbidden to bid for, to have standing? What case can you tell me when there was a categorical bar to someone participating because of their identity, they still had to nonetheless, and there was no question they're qualified, they have the ability, like Judge Rogers says, that they have the interests, that they're active in the area, none of those are in question, that they nonetheless have to say, oh, there's one that I want in that situation. It's their business to bid. It's their business model to bid. They're active in this area and they still have to wait for a project. They can't challenge the rule itself. And then what, challenge that project? What's your best case for that on a categorical bar like this?
Well, Your Honor, I'm not aware of a case.
No, and the prior LSP case was not that.
No, this is absolutely different. This is very different. Right, but I would expect that that
your position that for standing, I would have to do that. I couldn't challenge the rule up front unless there happened to be a project that was barred within 60 days of that order issuing. I couldn't challenge the order. I would have to wait for a project to come down the line 2 or 3 years later. And I would have to submit a completely pointless application and spend all the thousands or millions of dollars it takes to put that submission together to apply for something that FERC has said, as a matter of law, I'm not eligible to compete for. And then I would have, that's FERC's position. That's what it takes for me to have standing.
Well, I think, Your Honor, that at a minimum, a declaration would have to be submitted.
Well, I would have to submit a declaration that says, what would that declaration say? It would say, stuff that FERC doesn't dispute right now, that I'm a business, if this is what I do, this is what we do for a living. I'm in the area. I've competed for things in the past in the area, right? This is what I do. And it's nothing infeasible or unreasonable to think that I'm going to keep on doing. In fact, I'm telling you, that's why I'm bringing this lawsuit. I'm going to keep challenging this. But you have said, I'm going to do an affidavit that says FERC has said I'm categorically walled off. And if I weren't categorically walled off, I'd want to keep doing what I had been doing all the years before and that I do everywhere else in the country. That's what the affidavit needs to say.
I think the hypothetical you're posing, Your Honor, would be a facial challenge to, of course,
they have a facial challenge to your rule here. They have a facial challenge to your rule here.
Right, and the difference being that, as in the LS Power case, these projects have been ongoing. The exclusion from bidding for projects in the 100 to 230 kilovolt range predated this case. And let's not forget that in the orders on review, the commission actually lowered the voltage threshold. So the commission actually expanded the number of projects that are open to competition.
But not as much as Mr. Fallon wants.
Right.
So that's the harm he's depending on. That's the harm he's depending on. He said we asked for going down to 1,000. That's our position of what's required.
Did you have one
harmed by that?
Did you have projects in the 100 to 229 range that were not baseline reliability projects and were not other projects, and so were open to competition in the relative period since this order issued?
I am not aware of any that were.
Okay, then I'm not sure you had anything that they could have submitted paper to compete on. That seems to me sort of, it seems to me, if you're going to say they haven't shown standing, they didn't show us which project they want. You have to show, don't we have to have some plausible basis for concluding that there was something they could have submitted papers for? That they weren't
I think
categorically
you're-
called off of from this collective stream of exclusions that FERC has adopted?
Right, Your Honor, I'm sorry if I gave a confusing answer. I mean, there were projects in the 100 to 230 kilovolt range, and LS Power does talk about specific projects, but at no point did they identify any specific project that they would have bid on, and there was
No,
nothing
I'm sorry,
stopping
but I'm
them
gonna
from
try-
submitting a
sorry,
declaration.
I might have misunderstood your answer. I mean, I take your point. If there were projects in the 100 to 229 range
Yes.
that were not baseline reliability projects and were not other projects, so that they could have the other projects category, so that they could have bid on them and they didn't, or they haven't pointed to those. But that's what I'm trying to ask is if it's a null set because of you've got a series of exclusions here that FERC has adopted. So this is what's concerning me. If it's a null set of what they could have applied for, then I don't know why they needed an affidavit to say, or they certainly don't need to apply for, and they need an affidavit to say, there's nothing we could have applied for, but had there been, we would have. I mean, I think that's clearly, they clearly say that we want to compete. We want to compete for these projects. We have competed in the past. This is what we do for a living.
I understand that, Your Honor, but I think this is the LS Power case from 2017, right? That one of the two exclusions.
No, this is not that case because that was not a categorical prohibition. There was,
I think it was.
No, it wasn't, because there was some of the whole discussion in that case at argument was that in fact what you had was, well, we're concerned about the things where there's this category of things you can bid on, but some of them, not 100% of them, some of them might be subject to a state right of first refusal. But whether the state will do it, whether you can still compete when a state does, because these things change from state to state. They're not a monolith, as FERC explained at the time. And so whether in fact even the state, the rights of first refusal would in fact preclude competition was an open question. And then there was a redressability question that Judge Tatel raised, which was, all right, well, even if there is a right of first refusal, we can't redress it because the law keeps that in place. So that was you had particularized information that was needed there because of the nature of what was going on. But here what we have in their view is, and I don't think FERC disagrees, is a categorical rule. There's nothing fact specific that's going to change, and no one disputes that LSP is a huge construction company that has the ability to compete in there, that it has competed in here, that it has projects that it's been interested in and applied for. But then its theory is we've been walled off. And to say that they needed to identify a project when FERC can't tell me that there was one they would have been eligible for, seems to me at some point we can't turn this into code pleading, right? That's not what standing is.
Right.
If FERC could tell me there were ones out there that they could have identified that were something they could have competed for, that would be a totally different thing.
I'm not sure that there were, Your Honor.
Right.
It's possible that Ms. Valley might have an example. I don't know the answer to that. But I do think that there was a burden on petitioners to show the court that it does satisfy the Article 3 standing requirements.
Okay,
And I don't think that
they
was
said
done
that
here.
you don't again dispute that. Do you dispute that they operate, that they operate within MISO, that they've got the ability to operate within? No one, I think Judge Rogers said this isn't about ability to do it or interest. No, do you dispute their sincere interest in competing?
No, of course not, Your Honor. We do not
they want to
dispute
do
their
this.
interest in competing. No.
Well, I don't know what that means, just let me say. Sincere interest in competing. I mean, I'd like to go to the mountains someday, but that's not enough. All right, so.
We don't dispute that they're in the business right now of doing this very construction work that they're not allowed to do here.
No, Your Honor, we do not dispute that they're a competitive transmission developer.
I have a question on the merits,
Yes.
which is just looking at the basis on which FERC rejected MISO's first two proposals. It did so in part because MISO was going to calculate regional benefits for the sub 230 kV projects and then ignore them and allocate costs locally, right? But now MISO is saying, well, we're just not going to calculate the non-local benefits, and FERC seems to have approved that. Can you respond to the petitioner's head in the sand argument that it seems like what FERC has said is that MISO can allocate costs exclusively locally as long as it just doesn't know about whatever regional benefits the project might confer. Why is that not an apt characterization of FERC's position?
Right. So, Your Honor, going back to the orders that you are referencing, the first and second regional orders, as petitioners call them, the commission never made a finding that projects in the 100 to 229 kilovolt range necessarily produce regional benefits. So there's no finding that as a whole, in the aggregate, that those projects generally produce these broader regional benefits that that necessarily mean that they should be in the market efficiency project category. So that there just wasn't that finding, and that's that goes back to Old Dominion as well, where that case was a different case where there was a whole category of projects that was acknowledged to have regional benefits, and yet all the costs were allocated to a single zone. And there, the petitioner objected to paying for those two projects. So that's not the situation here. The commission has never found that lower voltage projects produce these regional benefits. And there is ample evidence in the record that it's reasonable to have a cutoff. It's reasonable to distinguish between the higher voltage transmission projects that are more likely to produce more widespread regional benefits and the lower voltage projects that tend to have local benefits. That's in Mr. Rose's
on that
testimony.
point, where in the record did FERC explain its rationale for not moving down to the 100 kilovolt threshold, but choosing the 230 kilovolt threshold instead? I mean, I take that to be the gravamen of Mr. Fallon's challenge on that point. And what is the explanation for stopping there?
So a couple, Your Honor. First, in a Section 205 context, the commission found that 230 kilovolts was a reasonable cutoff. And it's also important to remember the commission didn't even find that 345 kilovolts was an unreasonable threshold. Generally, the commission has found it is reasonable for the mid-continent system operator to categorize its projects. That's how it manages its transmission process. And the commission has found that to be reasonable. Now, in the Section 206 context, the commission found that LS Power had not met its burden of showing that 230 kilovolts is unjust and unreasonable, such that you have to bring the project threshold all the way down to 100 kilovolts.
So help me out with that. So FERC's decision in the Northern Indiana case dealing with interregional projects, the commission chose to take the threshold down to 100 kilovolts. And I guess that was in part because they wanted to make the MISO and the, PJM
Yes.
threshold consistent. But is there any tension in your view between embracing the 100 kilovolt threshold in Northern Indiana and not doing that here?
No, Your Honor, I don't think there is an inconsistency. Of course, the interregional cost allocation issue is before the court in case number 20-1262. And I think, as Your Honor is right to point out, there was a specific mismatch between the two regions in that case, between the Mid-Continent region and the PJM region. It was an entirely different record. There were specific projects that were being prevented from moving forward. These are specific projects that the commission had found would have interregional benefits to both of these regions. But the Mid-Continent voltage threshold and its project cost minimum of $5 million were preventing those projects from going forward. So in that particular context and on that particular record, the commission found that it was not just unreasonable to apply the thresholds. But
now here, petitioners are saying that there are a couple of projects in the 2018 expansion plan that as to which MISO determined that they benefited more than one zone, but nonetheless, they've treated them as purely local for competition purposes. And your response to that is?
So the commission explained in the orders that these are isolated examples that, do not, in your words, Your Honor, like, in the aggregate and on balance, show that the entire category is regionally beneficial. I mean, these isolated examples do not prove that, it's unreasonable to have a voltage threshold as a whole.
But you also had two applications before this by MISO in which it said, acknowledged it was going to have projects at a lower threshold, and they were going, the two that FERC rejected. And in the process, they were going to be able to identify, what do we call them, regional benefits, extra zone benefits, but that wasn't going to be factored into the cost allocation. Now I understand how you characterize FERC's decision there, but isn't that also evidence that at a minimum MISO thought was going to find regional benefits in a sufficient material number of cases to even go through the exercise?
I'm not sure, Your Honor. I think
Not
that,
sure?
I'm not sure what MISO was thinking.
I know, but I'm just asking on the paper that was before, FERC made two
Right.
decisions here and said, and acknowledge, look, your process is going to do this and it's going to identify this thing, but then you're not going to factor it into your cost allocation. Now, to be sure, FERC didn't say we agree they're there or not. But MISO itself, this is what I'm talking just about evidence before FERC. I'm not saying FERC already made the decision. Evidence before FERC was that, geez, MISO has already got this process in place. And, it's not in the business of running around Robin Hood's barn here doing things that are never going to materialize in anything, right? It's not in the business of spending time and resources identifying regional benefits that don't exist. And so those two things, and then so it comes in with the third application, and it's sort of like we're just not going to look, if we just don't look, then FERC will sign off on it. But why aren't those, plus the Northeast Indiana case, plus the examples that they've given, collectively sufficient evidence that FERC didn't grapple with in this case?
As I understand it, Your Honor, in the prior proposals, Mid-Continent was proposing to calculate the benefits and costs, both regionally and also locally. And Mid-Continent said, with respect to these projects that we're now talking about, that the local zone actually was receiving more benefits than it was paying in costs. So in the commission's view, that was. But
that doesn't mean that other zones aren't also receiving more benefits and not having a material amount of benefits and not having to pay a penny. That doesn't exclude that at all, does it?
Right. It's possible that these other zones were receiving some modest spillover of benefits, but
when do we do it? You don't know it's modest. How do you know it's modest? How do you know modest? By the way, how does FERC define modest?
I'm not sure if there is a specific numerical definition for modest, and it may vary depending on the region.
Really?
I'm not sure, Your Honor.
Okay, but like 40%? It doesn't feel modest to me, but I'm not the expert.
I think that the issue of the level of spillover benefits was more at issue in the baseline reliability.
No, I understand that. I'm just trying to understand what you're talking about, what kind of evidence you need, and that wouldn't have been enough because it might have been modest, but without knowing without FERC telling me what counts as modest, that would have been exactly something they could have done had they actually grappled with this evidence in front of them.
I'm not sure that there is a specific threshold, honestly, Your Honor.
Right. That would have been a good time to address that.
Right. But I think the commission found that the LS Power just didn't meet its burden here because it was two isolated examples, and the Mid-Continent.
There are two isolated examples, but Judge Pillard just flagged, just to be clear, it's not just that, right? They've got two examples, and you want to use the adjective isolated. They've got two examples. You've got the Northern Indiana case where the entire structure of it was a recognition that you can have regional benefits at this lower range of voltage. And that was enough to even motivate a between systems project like that. And that FERC didn't want to stop those types of things because there are these kinds of benefits. So you have that, and then you have twice MISO coming to you and for some reason going through a hunt for things that we can maybe just assume that MISO wouldn't have gone through the process of identifying regional benefits as it does if it was a null set.
Right, Your Honor. So
it's not just two. Okay, so we've got more than that.
Well, there were only two specific actual projects in the record.
There's a Northern Indiana case.
Yes, of course, the Northern Indiana case, yes. But that was, again, yes, Your Honor, that was different, and the commission found it to be different. I think what we have to remember here is the commission.
Run by me again, why is that different in the sense of why are the potential for interregional benefits in that case necessarily different from the potential from regional or interzone benefits in this case?
Well, two things, Your Honor. I think the commission found in the record there that there were these very specific projects that were being held up, and there different kinds of projects. These are interregional projects that could be located in PJM entirely with benefits to MISO, or it could be located in MISO with benefits to PJM. So the commission was clear it was looking at that particular record. I think what we're dealing with here is that the commission was finding that just the possibility of some projects in this range providing some regional benefits was not enough to show that it's not just unreasonable to have a voltage threshold. And it may be helpful to look at the commission's market projects order at JA 1039. It's paragraph 18. The commission is quoting some language from another case, but it is saying
I'm sorry, can you just tell me the page again? I apologize, sorry.
Oh, of course, Your Honor. It's JA 1039.
Okay.
It's paragraph 18. And the commission is talking about, is quoting from other cases, but it's explaining that by limiting transmission projects to certain voltage thresholds, that what we're doing here is establishing clear and objective standards and avoiding the need for the system operator to, quote, expend resources on the consideration of transmission projects that are less likely to provide regional transmission benefits.
By expending resources, you're talking about running a competitive process?
Right. That is part of it, Your Honor, yes. And the commission here is balancing the reality of the system operators need to expend resources, the administration of these transmission planning processes, which are large and complex and lengthy. So it's balancing those considerations against the needs for competition and for reliability and the broader public policy considerations.
I wonder if you had, I don't know if you were listening when Mr. Glover was on, but I wonder if you have any sort of bigger picture perspective that you can give us on why it is that, since Order 1000 kind of made this sea change and said, look, we think competition is really salutary. We're going to try to open up a lot more to competition. We're generally getting rid of rights of first refusal. And it just looks, however many years out, like, was that an overly optimistic expectation? Or like, how can we understand this as a healthy functioning under Order 1000 as distinct from kind of, incumbent actors with monopoly power just dragging their heels and FERC looking the other way? I mean, I don't mean to be, just trying to be tendentious in putting the question to see whether you can cast any light on that for us.
Of course, Your Honor. I appreciate the issues you are bringing up. And actually, all of these issues are under consideration in a holistic way right now before the commission. The commission actually issued a notice of proposed rulemaking on transmission infrastructure development. It's actually FERC docket RM 21-17. And many parties, including the system operator and the transmission developer here, have submitted comments to the commission about all of the issues, like all of these, about voltage thresholds, about immediate need reliability exceptions, about the myriad issues that go into these transmission planning processes. So I don't know how the commission ultimately will address these concerns, but they are front and center because we know the importance of transmission development, obviously, and the significance of competition. So these are issues that are very actively being examined.
What is this right now? What is this docket, and where did it come from, and what's the scope of it?
It is docket RM 21.
Yeah, you said 21-17, and you said that all these issues are under consideration. What is it like? Is it sort of notice of proposed rulemaking, or it's just a?
Yes, Your Honor. It was an advance notice of proposed rulemaking, and the commission is looking very broadly at transmission issues, especially as we know the importance now of connecting renewable sources of power to the grid, making sure that power gets to the population centers where it's needed. I mean, these are really difficult and important public policy issues, and they're front row center at the commission. So
what's the status of that? Because that was 2017. We're 5 years after that now. Is it still just an advanced notice of proposed rulemaking?
Oh, sorry, Your Honor. It's actually, I believe it was initiated in 2021. It's RM 21.
Oh, I thought you said 2017. Okay, I misunderstood.
Oh, I'm sorry. I believe it was 2021.
Okay. I misunderstood you, sorry.
I believe that was the date, and I might need to double check and I'll correct it. I will send a letter correcting myself if that's incorrect.
And that might be good that they're doing that there, but why? I mean, in these particular situations here, they already have Order 1000 on the books. Why wouldn't here have been the place to grapple with the implications of Order 1000 for these two categorical rules that issue here?
Right. Well, here in this particular proceeding, again, with respect to the voltage threshold, the commission is finding that it's not unreasonable to have a voltage threshold in this, that it is giving some deference to the regional stakeholder process that produced this. It was a 5-year-long process that involved a huge amount of give and take that ultimately produced the 230 kilovolt threshold. So there is that. And with respect to the immediate need exception, as your honors know, that exception is not specific and unique to the mid-continent region. That exception exists in 3 other systems that we know of. It's in PJM, in the Southwest Power Pool, and the ISO New England. Of course, the commission actually investigated the system operator's implementation of this particular exception and largely found that they were being implemented as designed.
I have some questions about this. So the commission's rationale was it has these 5 criteria that are supposed to limit and make it rare, I think was the word, or the exception that you'll have an immediate need, not the rule.
Right. It's 5 criteria that are supposed to help make it a limited exception.
Limited exception. Can you tell me, other than the requirement that they be online in 3 years, or the criteria actually just says needed in 3 years or less. Other than that one, can you tell me how any of these criteria do anything to limit these projects? I mean, posting an explanation, that doesn't stop anybody. Transparent process, that doesn't stop anybody. Receive comments, that doesn't stop anybody. And maintaining a list of past projects, that doesn't stop anybody. Have any of these criteria ever been used in any meaningful way to slow down how many things qualify as an immediate need exception project? They seem empty to me.
I'm not sure that they have. Well, I think that the criteria are designed to make sure that there is notice to all market participants and that there's the ability to comment on them. And there is also a dispute resolution process.
That was one of the whole issues here, was that you said, well, they don't have to do it before. That's the whole issue here. For example, you don't have to do it beforehand. And that instead you can, I guess, raise it back when they're deciding if something is a baseline reliability project? But not all immediate need projects are baseline reliability projects, are they?
That's right, Your Honor. So a couple things there.
How do you think this process works if someone could actually challenge it before it's too late?
Well, actually, Your Honor, I know that there is that statement in the order about the timing of the notice, but actually it is explained, especially in the mid-continent brief, I believe at page 15.
I know, where did the commission, I'd like to know where the commission explained this.
Okay, well, in the order itself, just after the sentence regarding the timing.
Are we on this is the same order you're talking about before the?
Yes, Your Honor. And I apologize. Let me just get the page for you.
I mean, on paragraph 23, I have the 5 criteria do not require MISO to post a description of need before designating the incumbent transmission owner.
Yes, Your Honor. I think that sentence may have been inartful because it's the sentences immediately after that on JA 1041 that show that MISO actually posts the reliability needs like during the baseline reliability study process. And this study process does take place before the incumbent transmission developer is designated.
If someone, that's just MISO. If someone wanted to challenge it, there's nothing you can challenge at that point, right? That's just MISO collecting comments.
I believe that any market participant could submit comments within.
Submit comments is not a limitation. Submitting comments is not a limitation.
Well, they could challenge it. I mean, they could challenge it within MISO during the baseline reliability study process before.
To FERC, they can bring it to FERC.
They certainly could file a Section 206 complaint to FERC. Yes.
Before when MISO tell me, I don't know how this process works because this, and I certainly don't know how it works if the immediate need project is not. Are all immediate need projects baseline reliability projects?
No, not necessarily, Your Honor.
Okay, so then this process doesn't work then.
No, I think it does work, Your Honor. That the commission found that the process actually did work in 3 other regional transmission systems.
No, it said we have those criteria in 3 other ones. It did not. I saw no finding that in fact they actually were working to limit anything.
I apologize, Your Honor. What I'm referring to is the other case that was recently argued to the court. I'm just saying that. I'm just still trying to understand how this is actually, because I read those criteria and particularly in light of the commission's decision in this case, that it doesn't have to be before. I don't see how submitting comments to MISO. You submit comments to MISO and then MISO says, when do they say, no, we're going to treat it as immediate need and designate the incumbent transmission owner? When do they do that? I believe that is after the baseline reliability study process, and Ms. Valley may be able to shed some additional light on it. Well, wait, the commission embraced this. The commission said this is our check. This is our limit. So I'm hoping that the commission can tell me without asking MISO to do the work for it. I can't review MISO's decisions. I can only review yours. Of course, Your Honor. What I'm saying, though, is that there is the opportunity to challenge the reliability need finding within this baseline reliability project process. And there is always the opportunity to bring a Section 206 complaint to the commission. You can bring a Section 2, at what point? Most likely when the whole thing's done and over and we've already designated the incumbent transmission owner. Well, I think as Judge Rogers was pointing out earlier, there's nothing stopping from somebody from seeking a stay from the commission or from the court for that matter. The commission, this is your big check. This is commission's sole real check on these reliability, this would be an immediate need projects, is that somebody has to bring a 206 challenge to a MISO determination to give something to the incumbent transmission owner. And that's not good enough by itself. They're going to have to get a stay and demonstrate a likelihood of success, even though all these criteria will be met. You're not going to give them a stay when they've met all the 5 criteria. Right, Your Honor, I couldn't comment as to what might happen in any given situation, but I would like to take one step back. The immediate need reliability exception is recognizing that there are some truly urgent reliability needs, if there is a violation of North American Electric Reliability Council standard, then that issue has to be addressed very quickly. So to avoid brownouts, to avoid.
I understand that, but it sounds like, so the commission told the Seventh Circuit in its LSP case, the one that was at issue in the baseline reliability ones, the commission told the Seventh Circuit that most, if not all, baseline reliability projects are online in 3 years. And then in fact, one of the factors the commission has balanced in its decision-making is MISO's desire that all baseline reliability projects be online quickly. Now, if these criteria aren't going to be much of any real check at all, and at least within MISO, I don't know about these other regions. I don't know if they've told courts that they do everything in 3 years, but at least as to everything that the commission has talked about here, which is baseline reliability projects that qualify for immediate need. That's the only thing that's mentioned here. The commission's already told the Seventh Circuit, that's all. It's not a limit, it's all of them. Most, if not all, is the quote from the Seventh Circuit transcript right around minute 30.
Right, so Your Honor, we're not talking about it, just the baseline reliability.
That's all the commission talks about here.
But they have to be, what we're talking about is the universe of projects that are baseline reliability projects that also meet the criteria for a market efficiency project. So
right. The criteria, well, we just talked about this criteria. Right. Those 5 criteria are not a limit at all.
Well, no, but that also meet the market efficiency criteria that, you know, that these projects are 230 kilovolts or more, and that they cost $5 million or more. And the commission here is recognizing the reality, which is demonstrated in the record, that the competitive developer process is a lengthy one. And
does it have to be? Could the commission not allow, or could MISO not propose an expedited bidding process? The government does this all the time.
I think that Mid-Continent has tried to expedite its processes, but no matter what, there is time that is required to
okay, but that's a totally different reason,
and to review all of these. Right. But that's the reason for the exception. I mean, that's the reason for its existence.
No, but what I'm trying to get at here, I understand that that's commission said, but it said this is going to be limited. And yet there's nothing limited. We know at least for those baseline reliability projects that qualify as market efficiency projects, or might, and those are the only things that the commission talked about here in telling us where someone could bring a challenge in the baseline reliability project assessment stage. The commission has already told the Seventh Circuit that MISO's view is we want most, if not all, online within 3 years. That's not limited.
I think because it has to meet the other market efficiency criteria. I know. Also in the record, I guess
I'm just asking whether all reliability projects, virtually all, are really going to end up falling within this exception, because I understand the rationale for why nobody wants reliability to take 10 years. Right. But the commission can't have it both ways. It can't say it's going to be a limited exception if in fact most, if not all, to use your words, reliability projects are going to fall within this time period.
But I don't think that's correct, Your Honor, that most, if not all, reliability projects will fall within that
in
time
MISO?
Period. Actually, right. I mean, actually at JA 320.
Okay, I'm just quoting from what the commission told the Seventh Circuit.
Right. So in this record,
they told them other things too.
Right, Your Honor, and I don't have before me the record in that proceeding, but here Mid-Continent submitted testimony at JA 320 that it was estimated that this exception would impact approximately one baseline reliability project per MTEP cycle, and that's every 1 year transmission planning cycle within the Mid-Continent region. It's at the bottom of page.
Does that prove true?
320. Your Honor?
Has that proved true?
I'm not sure, Your Honor, but that was the prediction that the commission was making on the record in this case.
One out of how many?
Predictive judgment.
One out of how many?
There are As I
That would
understand it,
qualify as that would qualify as market efficiency projects for which there could otherwise be bidding.
So one out of all of the projects in each of the transmission planning process cycles, which potentially could be hundreds, and Ms. Valley can correct me if that's
No. We have
incorrect.
to talk about how many that would qualify as a market efficiency project for competitive bidding. It doesn't say any good to say, well, it was just a baseline reliability project, because those have been carved off from competition. That's not a limited category. Or those that would qualify as other projects. That's certainly not a limited category. That's the majority of projects that MISO proposes now. It's for many years now has been other projects. So that's what I'm asking.
I'm not sure that that information is in the
Okay.
record, Your Honor. At least I
So
haven't
just saying
seen-
one doesn't really tell us a lot. Yeah.
Right, no, Your Honor. And I don't think that LS Power made the showing in its Section 206 complaint that, as far as I'm aware, there wasn't an adequate showing that this exception would swallow the rule. But in any event, the commission is also, it has made clear that the Order 1000 planning process is about process. It's not intended to dictate substantive outcomes. And that is one of the principles that the commission was operating under when it considered how these exceptions are being implemented in multiple regional system operators. And
I understand, but if you have a system operator who's committed to doing these things in 3 years or less, that seems a different situation that should be grappled with. I just have one last question. I know we're way over time here. In their, back on standing, in their reply brief on page 5, LSP says the record includes evidence of 2 regionally beneficial 161 kilovolt economic projects included in the 2018 MISO transmission expansion plan that petitioners were prohibited from competing for because they were designated other projects and didn't meet the voltage threshold. If they had cut and pasted that into a declaration, would that give them standing?
I'm not sure, Your Honor. I think,
Why not? What part of your theory of standing doesn't it meet?
I think it would. Right. I think the declaration still would have to include some other information about.
Like what?
About the specific project that they had the ability to bid on it, and that they otherwise satisfied Article 3 to.
Well, I don't understand what else aren't you arguing? I mean, you're not arguing causation or redressability. So what you've been all I've heard you argue about is injury in fact. And why isn't that an injury in fact?
Right. In that scenario, yes. I mean, yes, the injury it is arguing competitive injury. Right, Your Honor.
How can you keep wanting to do imminence and then they have to wait for another project to come along? They want to challenge your rule.
Actually, there are a lot of assumptions underlying Judge Millett's questions, and counsel, I don't think you're in a position to make concessions for the commission.
That is right, Your Honor. I'm not in a position to make those concessions.
Okay, I thought she was in a position to argue Article 3 standing.
Well,
That was my last question.
Okay. Your Honor, I just don't think that it has been demonstrated in the circumstances of this case. And I think that the petitioners could have made more of an effort to demonstrate its standing with greater specificity. In sum, I think the commission was balancing multiple considerations here. I mean, it has to balance the interests, it's competition, not just for the sake of competition, but for, it's also balancing the reliability needs on the grid. It's balancing other public policy objectives. And it's also operating under the presumption that there is no one size fits all approach for each region, and that regional stakeholder processes do mean something. So it made the decision here that it was not unreasonable to have a voltage cutoff for this market efficiency project category. And I think that the orders reasonably explain the commission's findings.
Thank you.
Thank you, Your Honor.
Counsel for interveners.
May it please the court, I am Carrie Valley for Mid-Continent, appearing on behalf of interveners for respondent FERC. I think there are a lot of questions that have come up today regarding the MISO process and planning and how it works and the whole framework that's been presented in these cases. And so I have highlighted a few of those areas I'd like to touch on that were brought forward in this discussion and might just work back from where we most recently were. Certainly, the petitioners here have raised issues with the two projects in MTEP 18 that had benefits beyond the local zone. It's important to recall that MISO itself presented that analysis, and that analysis demonstrated that the local zone in both of those cases had benefits in excess of costs. That meant the standard for meeting that the costs and benefits are roughly commensurate was met in both of those cases. And the circumstances that the petitioner have raised do not change that. When going to the issue of the specificity for making it standing case, the petitioner itself has raised these two questions, and whether or not they could have indicated that they had an ability to would have bid on those projects. If that is the court's question, those projects and what they were certainly presented in our stakeholder process, and I believe that the petitioners could have made that case if they had intended on those cases. One where getting back to the most recent discussion on the immediate need reliability exception, it is very limited. The petitioner in its case outlined the total number of baseline reliability projects. That is not indicative of the projects that are going to be baseline reliability projects that also meet the MEP criteria. We expect that to be a very small universe. But nonetheless, in the stakeholder process, moving to present, what should, if any, cost allocation changes should we have? What do they look like? What are the improvements, and what are the concerns that might arise from that? It arose in the stakeholder process that by lowering the voltage for market efficiency projects, you might incorporate more baseline reliability projects that met that MEP criteria. And I think I need to step back one moment. Under the MISO project hierarchy, a project will be allocated based on its essentially highest value. So if you are a baseline reliability project and also meet a market efficiency project criteria, you're going to be allocated as a market efficiency project. If you're
get competed.
Exactly. Yes.
Unless it's immediate need.
Unless it is immediate need. And where we found here was that universe of projects might bring up a baseline reliability project that was needed within 3 years. And the commission has an established framework for saying, yes, we want to make sure that reliability is not impaired by the competitive developer selection process that adds, potentially a year, to that moving forward on that project. And so for this discrete number of projects.
Well, that's what can you tell me? Sorry. Can you tell me if it's really discrete? Because that's where I'm getting mixed signals. I told you what the commission said, MISO had said to the Seventh Circuit, most if not all. Baseline I get that, but you were talking now about baseline reliability projects that elevate to the market efficiency standards. So that's the framework we're talking about right now. That most if not all baseline reliability projects within MISO are completed within 3 years, because MISO understandably wants to do reliability projects fast. I mean, that's why it's called a reliability project. Is that accurate or not accurate?
It's not, I wouldn't say it's not what MISO wants. It's what comes out of the reliability study. So our planning process identifies a transmission issue, then evaluates proposed solutions. And it is not only MISO's solution or the owner's solution, it is those things, and any stakeholder can present an alternative in that process. So there is an ongoing process to evaluate those reliability needs and what that reliability need is and how it's going to be met. And so that is how that is identified. Some of those are near-term needs, and we want to make sure that those near-term
When you say some, I'm really trying to understand how many are online within for reliability projects.
Yep.
Baseline, other projects, whichever one, market efficiency, how many are online, or at least at the time you're picking who's going to develop it, at the time of the developer selection, are to be online within or needed within 3 years?
I'm not sure I'm exactly following Your Honor's question in terms of how many of those baseline reliability projects are presented with that, 3-year time frame that it has to be in service. I don't know that exactly.
I'm not asking exactly. I'm at rough. Really, I'm trying to understand here whether this is in fact a limited category or not.
Well, what is the
help me understand that?
Yes. What is the limitation is that baseline reliability, the project that also meets a market efficiency project criteria. That is the big limiter in this case, that only for those baseline reliability projects, because otherwise.
I know, but if just to qualify as a baseline reliability project, in practice, those are all coming online within 3 years, or most, if not all, are coming online within 3 years, then saying, well, it also counts as market efficiency isn't going to change that fact. So
I understand what you're saying. Yep, I understand. Yes, Your Honor. And I don't know. I don't have that exact answer for you. What I would offer is that the baseline reliability projects generally are just baseline reliability projects. It is only, we want to make sure for that instance where it is also a market efficiency project that we meet that reliability need. And I know that Your Honor had asked the question of how many of these have there been. We had in our testimony that we expected maybe one per year. This tariff framework only became effective in 2020. We've only recently concluded the one planning cycle that came after this. And so we don't have any in that cycle that meet that criteria. So we did not have one come.
Didn't have any market efficiency.
No. In the one cycle. We've only had one cycle since this tariff framework was fully effective. It became effective at the end of a process that had started significantly in advance of its effective date. So we did not have those.
But you've had baseline reliability projects for a long time.
Yes.
As to that category, do you know if in fact it was accurate to say most, if not all, are online within 3 years?
I do not have that information.
Okay.
All right. Anything further?
Yes, I would like to touch on a few other things that the
briefly.
Yes. Number one, the LEP project, or I'll touch on NIPSCO first. The significance
on what?
The interregional market efficiency project between Mid-Continent and PJM. That is a unique circumstance. The court had been the commission had been presented in that case with evidence to suggest that these lower voltage projects could have congestion benefits to both regions. And based on that limited record in that case, directed MISO to lower the voltage threshold for only projects between Mid-Continent and PJM. Parties had argued for a broader application and the commission rejected it as there wasn't evidence to support a broader application. Those projects are, as Commission Council had noted, can be located in either region. They are intended to facilitate improved congestion between the two RTOs and are uniquely separate from or different from the regional MEPs. And when the commission had made that initial order, it did note that, what was the cost allocation going to be? Was it going to be the same or different? And MISO moved forward and we had a lengthy commission proceeding on exactly what that cost allocation would be. I also wanted to note that on the causal connection, the petitioners in this case have raised a number of issues with economic other projects, but have identified no causal connection that on a global basis, these economic other projects have region-wide benefits. There were 2 projects identified, and those projects also exhibited benefits in excess of costs to the local zone. And that is what is important to show that existing cost allocation method continues to be effective. And then I did want to touch on a little bit about the local economic.
All right, that's point 3.
Thank
you had 2 points.
One, I did want to touch on the local economic project category that was previously rejected by the commission. It's important to note that in that case, MISO and its stakeholders had attempted to create a new project category and presented it to the commission that was ultimately rejected. But in that case, that did not remove the other project category from the MISO tariff. That other project category cost allocation method was still eligible for projects that wouldn't have met that new project category. So that it's important that while we attempted to create a new framework, it ultimately was not successful. It did not change the fact that the existing cost allocation method for other projects is just unreasonable going forward.
All right. Thank you, counsel.
Thank you.
All right, counsel for petitioner.
Thank you, Your Honor. I know the court's been at it for a long time this morning. I don't want to be respectful of your all's time.
Right, briefly.
Yes, but I would like to talk about a little bit the relationship between Northern Indiana. And in Northern Indiana, there were these projects. The commission found there were significant regional benefits between the two regions. And the commission relied on a quote unquote quick hit study. And that study showed that the projects 138 to 161 kV had significant regional benefits in both regions.
And how does that help you, counsel?
Because the only difference in this case, Your Honor, is that our projects are, this project is only in the MISO. It's solely within the MISO. And in the Northern Indiana case, they were talking about interregional market efficiency projects under the PJM MISO joint operating agreement. So
and
here we're just talking
your projects.
Our projects are solely within MISO.
What projects? Your clients don't have any.
They're talking. You're talking about market efficiency projects?
Yes, market efficiency projects, Your Honor.
All
Yeah.
right. So you're saying within what? There are only two.
No, Your Honor. What we were saying is they did this quick hit analysis.
That was in the Indiana case.
That was in the Indiana case. In our case, they looked at 10 projects in the MISO stakeholder process.
Right.
And all 10 of those projects were between 100 and 229 kV. And all 10 of those projects had regional benefits to the project where the project was located, and also to other regions within the MISO.
Did they outlay local benefits in the commission's expert opinion?
Your Honor, the solicitor, the commission never said in this case that it's okay because the local zone benefits more than they benefit more than their cost. They never said that. And I think there's a good reason why they didn't say that, because they can calculate the benefits. And so if first of all, it's a post hoc rationalization on the part of FERC.
Well, did you present evidence to the commission?
We showed that the 10 projects that were in the stakeholder process, the 2 projects, we also showed the connection in the Northern Indiana case. We also showed the connection between congestion and the projects that solve the congestion.
All right. Anything new, counsel?
No, Your Honor.
We'll find it in the record.
Yes, Your Honor.
Thank you, counsel.
Thank you, Your Honor.
Thank you all, counsel. We'll take the project, we'll take the cases under consideration. Thank you.
Thank you, Your Honor.
This honorable court is now adjourned until Tuesday, February 8th at 9:30 a.m.